Someone make it make sense.
Probably a couple.
Hello, hello, hello. We are back for more Squirrely Streamathon. How's it going, guys? God, I need some more chapstick. I'm telling you, it is so dry here. Let me grab my chapstick real quick so my lips don't start bleeding while I read all these documents. Hold on just one sec. We don't need any bleeding all over the place, do we now? Do we now? Welcome, everybody. Yeah, where's Rochelle? Rochelle, get over here. Squack. We need a squack. What should that be? It's a good one. It's a good one. Okay. So, chapstick complete. Lips are not bleeding. The goal is a good place to start, isn't it? Isn't it? Isn't it? Alrighty. So we are starting off strong here with the state's motion in limine in re regarding investigative genetic genealogy, and this was filed on surprise, surprise, February 24th. All right, comes now. So moves the court in limine for an order 1, describing the extent to which the parties can refer at trial to IGG used in this case, and 2, excluding from the trial any testimony or evidence related to the DOJ interim policy on, that's fucked up. Sorry, that's fucked up. The DOJ policy on forensic, dude, you know they don't want that, of course, right? Jesus Christ. The DOJ policy, we all know what that is. The terms of service of any of the genetic genealogy subscription services, Jesus, the policy debate on whether law enforcement should use IGG in criminal investigations and any alleged discovery violations. All right, the name Bryan Kohberger first appeared on law enforcement's radar in this matter because of IGG. At least they're not hiding that anymore. And IGG has been the subject of much litigation in this case. No kidding. Most recently, the court found the use of IGG during the investigation did not violate defendant's Fourth Amendment rights. The remaining question is the extent to which the parties will be allowed to discuss IGG and related information at trial. The state's view from the outset has been that the IGG information was, quote, nothing more than a tip, end quote. Just the tip, guys. That's what she said. And was never intended to prove or substantiate defendant's guilt. Shout out to Tonka, who's a new member. Awesome. Love it. Welcome, welcome, welcome. We love our members. We already have quite a bit of members-only content available for you guys, and always open for suggestions, as I've said. Let me know if you guys have any things you'd like to do for members-only live streams. Okay, so instead, the state planned to rely at trial on the evidence developed after the use of IGG, such as the STR DNA analysis that found defendant's DNA matched to the DNA collected from the K-bar knife sheath. The state also made clear from the beginning that it would need to reference the IGG information in some manner at trial, even if only as a generic tip, to help the jury understand how the investigation progressed. Yeah, eventually at some point, it must have started to sink in. There's no way they were getting around that, right? The defense, on the other hand, has been all in on presenting the IGG at trial. I mean, that's not like a legal standard, like all, okay. Anyway, it has now disclosed to 2 experts, Leah Larkin and Daniel Hellwig, whose sole focus, I really liked that Daniel Hellwig from what we read in that transcript, whose sole focus is information related to the IGG. The disclosure from Ms. Larkin indicates that the defense wants to discuss more than the IGG itself, but also present to the jury information one step further removed, including allegations that the FBI's use of IGG in the investigation violated a U.S. Department of Justice policy, the terms of service of certain genetic genealogy databases, and foreign law. The state now seeks an order from this court describing the extent to which the parties will be allowed to reference IGG at trial and excluding the more tenuous information disclosed by the defense. Subsection A, the court should enter an order describing the extent to which parties can refer to at trial to the IGG used in this case. I mean, this wouldn't be a problem for them if they didn't, rely on it. You know what I mean? Just saying. It's their choice. Yeah. So get some blunt force trauma going. The state should be allowed to present the IGG information at least as a generic tip to help the jury understand how the investigation progressed. Well, it was the entire quote-unquote investigation. So anyway, evidence must be relevant to be admissible. Yes. Idaho rules of evidence. Evidence is, I almost said elephants. Evidence is relevant if it has any tendency to make a fact more or less probable than it would be without the evidence. And the fact is of consequence in determining the action. Testimony from an investigator as to how an investigation progressed can be relevant and admissible. Yeah. Normal. Can you imagine if they presented a case like in any trial and it's like they didn't explain anything? They're just like, they're guilty. Like, what else are they? What is the point if not to show how you got to the suspect, right? Isn't that like the whole fucking point? Anyway. Oh, George. Well, I hope your leg is healing, and I hope George is also unscathed though too. In Hall, a detective testified about how he used DNA to eliminate an individual as a suspect in the investigation. The district court overruled a relevancy objection, and the Idaho Supreme Court affirmed. The court explained that the testimony was relevant because it provided the jury with a complete story, and that it explained why the police no longer considered the individual a suspect and provided the jury with details about how the investigation progressed. The court also observed that the testimony was relevant to refute the defendant's. By the way, members, y'all can put a George emoji in the chat as well. Oh, and thank you for that. A George is a George, of course. Awesome. Freaking George with his freaking gas cans. I wish they had a duct tape emoji. People who make emojis, if you're listening, whoever you are, we need a duct tape emoji, please. So observe that the testimony was relevant to refute the defendant's contention that the former suspect was involved in the victim's murder. That is not to say, however, that such testimony is always relevant and admissible. Always a good tip here. Don't pick the scabs. Well, we hope you do. We hope you're going to get better. But I am glad that George is okay because George is really cute. In Boner, oh, okay. I literally said this, and that's like, then I was like, oh, that's what that says. Okay. An officer testified that a dispatcher had told him that the defendant had said he wanted to kill a cop. The district court overruled an objection on the basis that the statement was offered for the limited purpose of showing what information the officers possess and how this information might bear on the subsequent actions of the officers. The Idaho Supreme Court disagreed, finding that limited purpose was not relevant. The court reasoned that the facts of consequence during the state's case in chief were facts bearing on the elements of the offense charged, and evidence of the motives of the officer's actions on the night in question did not prove any element of the offense charged. But the court noted the testimony would have been relevant to rebut a defense challenge to the reasonableness of the officer's conduct after hearing the radio report. Here, the IGG information falls on the Hall side of the line, presenting the fact that law enforcement received a tip directing them toward defendant is necessary to provide the jury with a complete story by explaining why law enforcement considered defendant a suspect. And unlike the challenged testimony in Boner, the IGG information is relevant to rebut a defense challenge to the reasonableness of the officer's conduct. Specifically, the defense has signaled its plan to present to the jury the theory that law enforcement rushed to judgment when it focused on the defendant as a suspect. Oh, they're referencing Ruth Ballard there. We did a semi-deep dive on her last night, Ruthie. The IGG information is relevant to refute that theory. Thus, the state should be permitted to present the IGG information at least as a generic tip. Subsection B. This court should exclude from trial alleged violations of the DOJ policy. Alleged violations? They admitted to it. Of the DOJ policy, terms of service, and foreign law, policy debates about privacy, and allegations of discovery violations. Wide and long, that's what she said. No matter how the court rules on the extent to which the parties can discuss at trial the IGG conducted in this case, the court should exclude as irrelevant and prejudicial several categories of information the defense has indicated they plan on raising at trial. The Idaho rules of evidence require the evidence be admissible. Right, we know. We fucking know. Whether an issue is relevant, right, we know. All of this is all, yeah. Okay, first is First, this court should exclude any testimony or evidence that the FBI, hold on. Let me read that again. First, this court should exclude testimony or evidence that the FBI's use of IGG in this case violated the DOJ policy, the terms of service of certain genetic genealogy subscription services, or any foreign law. None of these allegations, even if true, bear any weight, bear any weight on the issue of the defendant's guilt. Tellingly, throughout all the IGG litigation in this case, the defense has failed to articulate any theory by which the alleged violations of the terms of service, DOJ policy, or any foreign law could have any effect whatsoever, on the reliability of the IGG process. Instead, the defense pieces together those alleged violations together to include, the defense pieces those alleged violations together. Okay, it's not redundant after all. To conclude, the FBI would not have identified Mr. Kohberger so quickly had they followed protocol. Facts. But the speed with which law enforcement identified the defendant has no bearing on whether the defendant committed the charged crimes. Well, it has to, dude, this is bullshit, because rush to judgment comes up in so many cases. So many. So does, the thoroughness of the investigation. Okay. The evidence is also inadmissible under Rule 403 of the Idaho Rules of Evidence. The presentation of this evidence could unfairly prejudice the state's case. Yeah, the state doesn't have any fucking rights, by the way. Bill. If one or more jurors decide to give unrelated evidence less weight because they believe the FBI violated the DOJ policy, the terms of service, or foreign law, even though those alleged violations could have no effect on the defendant's guilt. Moreover, so in other words, this is literally what the defense obviously argued, right, in their motions. And he's right that the jury could still find that. Maybe they will. That is fair, my opinion. Moreover, allowing the defense to present this evidence would turn the criminal trial into something it is not. Well, what is that? It's still a criminal trial, right? Well, are you going to say what it turns it into? What does it turn into? A pancake? A flamingo? What the fuck? As this court observed, violations of the database's user policies, quote, may give rise to a civil action between the FBI and the particular database, or perhaps the individuals whose DNA profiles were used, end quote. But that action would be between the two other parties in an entirely different case. Well, we know that's not the thing anymore. Litigating that case during this trial would risk confusing the issues, misleading the jury, undue delay, and wasting time. I disagree with that. Second, this court should exclude any evidence or argument on the policy debate of whether law enforcement should use IGG in criminal. I mean, I do agree with that part of it. I think that will be something that will continue to be discussed and would be more of like a Supreme Court thing. I don't think that is as relevant for this trial, but everything else so far, I think, is extremely relevant. Right. And then mentioning the house. Yeah, the IGG, again, the medical stuff. Again, now what is interesting though, this is interesting because now this is a little bit different context, right? Because all the whole thing with the medical stuff, but one of the things listed here is autism. Biomedical details. Whether as a matter of policy, law enforcement should use IGG in criminal investigations has nothing whatsoever to do with the issue of guilt in this case. The court has already resolved the privacy issues as they relate to the Fourth Amendment. Any residual privacy concerns fall within the purview of the legislature, not the courts. I mean, I do agree as it pertains to if law enforcement should use it or not as a policy issue, right? And certainly not juries in criminal trials. If the defense is allowed to argue privacy policy to the jury, there's a significant risk that a juror will make their own decision in the case based on their subjective view on privacy as opposed to their view of the evidence with respect to the defendant's guilt. What the fuck is a hantavirus? I've never heard of that. Third, this court should exclude any evidence or allegations related to the discovery process in this case. Whether the defense received everything the defense believes it was entitled to during discovery has nothing to do with the defendant's guilt. Well, okay, whatever. In allowing the defense to argue to the jury that the state should have produced more in discovery, they're doing, this is a strawman argument because that's not really the issue. The issue is like they can't show their work and they're supposed to be able to show their work and they can't explain things like the doubling in size and all the rest of the fuckery, right? It's akin to like a chain of custody with other things, right? It's akin to a lot, like there's a lot of other examples that are very similar that, again, come up in like every trial. Anyway, significantly risks unfairly prejudicing the state. Again, the state has no rights, by the way, again, Bill, by improperly and inaccurately suggesting the state has hidden information to which the defendant is legally entitled. Well, jury's still out on that one. The state therefore respectfully submits stupidness. Okay. Okay, thank you for answering that. Interesting. I wonder if the rat babies have it. Okay, so now that we've read the state's motion in limine regarding the IGG, now we are going to read the defense motion in limine. And there's a couple of these. So that one, and we need Mittelman. So let me just see here. That's Mittelman. This is, where did it go? Okay. So now, again, the defense motion in limine for the IG. So exclude IG evidence. Okay, comes now. Everybody be coming. All right. Exclude the evidence of IgG testing and searches. Relevant facts. A knife sheath that was recovered at 112 King. So, okay, this is interesting because I kind of thought, I mean, even from what the state said, right? It seemed like the defense wanted to get into this, right? So I don't know. Let me keep reading. A knife sheath that was recovered, We all know. The MPD, with the assistance of the Idaho State Forensics Lab, transferred extracted DNA from Q11 to Othram Labs on November 22nd, 2022. Othram promised to preserve all of its work in this case in the engagement agreement and proceeded to test the Q11 DNA using SNP techniques. Othram generated a profile, in quotes, using SNP and began building a family tree for Q11, looking for the closest relatives of the sample in commercial databases that allow law enforcement searches, GEDmatch Pro, and Family Tree DNA. On December 10th, and the thing is this, the family tree thing, I still just don't buy it fully. And, you know, the thing about the brothers, that was their whole thing about, like, that's like their family tree. But, like, they're not able to produce any evidence of them. So, I don't know. I think Heather would have thoughts on that as well. I think she and I have been on the same page as far as that's concerned, like, since day one. On December 10th, 2022, Othram was asked to cease work on the case by the prosecutors, despite the fact that their genealogy investigation was incomplete. Footnote 1. Oh, motion in limine. Okay, fine. Othram reported that they had identified a number of close relations to the knife sheath via searches of Family Tree DNA and GEDmatch Pro and suggested obtaining DNA samples from 3 individuals to further their investigation. In an email directing the stop work, lab manager Matthew Gumet directed Othram to, quote, preserve the whole genome profile that you've generated on this case, any remaining DNA extract, any data generated, any other records, and anything else laid out in the contract. Basically, preserve all your shit, basically. Okay. After Mr. Kohberger was charged, he swiftly requested discovery relating to the IGG testing in the family tree building that led to his arrest. Mr. Kohberger laid out the rationale for his request in his third motion to compel and a series of affidavits. Heather's peeing on her dog, probably. Just kidding, Heather, if you're listening. Right. Well, yeah. And of course, it's like we're getting there, right? So, okay. The state filed a motion for protective order in advance of Mr. Kohberger's motion to compel. In the motion for protective order, the state drew a strong distinction between the work done by Othram to generate a SNP profile and the work done to generate a family tree from the SNP data. In effect, arguing that the family tree building did not fall under the Idaho rule of discovery for a number of reasons. However, in this motion, during argument on the motion, the state conceded that the testing done by Othram to generate SNP data fell under ICR and stated, quote, the private laboratory developed the SNP profile from the DNA on the K-bar knife sheath. As required by Rule 16b-5, the state will produce and report that documents the DNA test. The court, after hearing testimony from a number of defense expert witnesses, found that the defense had met the threshold required to show at least some of the IGG information sought as material to the preparation of the defense, and issued an order for the production of all IGG information in possession, custody, or control of the state. On November 30th, 2023, the state provided materials to the court for review, along with a table of items. The listed items include FBI materials and, Othram shit, basically, Othram contracts, right? Court ordered release of the majority of materials with the exception of the generic contract documents of the MOU, which was the Memorandum of Understanding between the ISP, Moscow PD, Latah County POA, and Othram. After review of these materials, Mr. Kohberger requested additional discovery materials in his 15th supplemental discovery request relating to the work done by Othram and the FBI. Footnote 4. Yeah, okay, another motion in limine, fine. He sought materials to encompass essentially all the materials that are normally produced along with lab reports for scientific testing. State objected. Mr. Kohberger filed his fifth motion to compel. In a hearing on May 30th, we all remember that one, extensive expert testimony was again heard by the court as to the necessity of materials sought. The requested items included, among other things, raw data files for the SNP testing, standard operating procedures, validation summaries, contamination logs, and bioinformatics programs and protocols. At the end of the testimony, the state, through Mr. Nye, argued the motion to compel. In a striking exchange, Mr. Nye represented to the court. Before I read that, I'm going to say shout out to Too Fast. Happy to see you. What are you eating? Let us know what you're eating when you're done lurking. Shout out to all the lurkers, by the way. Okay. So in a striking exchange, Mr. Nye represented to the court. The court makes the decisions, and we so complied with that order. And we reached out to the FBI and Othram and said, you got to give us what you have. We've talked a lot about, and we've referenced a letter from the FBI today. I thought the letter itself did a pretty good job laying out what they do and don't have, what they have access to and what they don't. We've talked to Othram. We've spoken to Othram since we got this exhibit and provided them these requests. And we are not in the position, for example, request 1 through 6, we are not fighting those. I'm not saying we are not going to turn this over. In my view, they fall pretty clearly under the court's order. The issue is we go to Othram and show them these, and Othram says, we've given you everything. You have everything. This is just like what they've said with literally everything else, whether it be the FBI or whether it be MPD or whatever. It's like, dude, I just can't. You have everything. Everything was given to the court and then provided to the defense. So there's nothing on this list that we are holding back because we think we have some justification. Mr. Nye emphasized that Othram told the prosecution that as to the specific requests, Othram is just telling us we don't have it, so there's nothing we can do. The court then inquired. The court. So Othram has said, you've asked them, and they said, we've given you everything we have. Mr. Nye said, yes. Bologna, cheese, mayo, mustard, lettuce. Oh, nice. What type of bread? What type of bread are you working with? Mr. Nye reiterated that the state knew that if the documents listed in Exhibit N 1 through 6 existed, the state had an obligation to turn this material over to Mr. Kohberger. And with the rest of it, we are turning it over if it exists, and if we have it, that's all. In the court's order related to the specific request in Exhibit N, the court relied in toto on the representations of the state, specifically referencing Mr. Nye's statement about items 1 through 6. Quote, the state indicated that the material sought in this request does not exist. Do not pass go. Do not collect $200. I was never the biggest fan of Monopoly. What about you guys? It was not my favorite board game. This is kind of a follow-up to last night. We've talked about board games for a little bit. It was not one of my faves. Oh, okay. Thin white sandwich, but we're making you hungry. Life cereal. Interesting. Beans and rice with interesting. Have any of you guys ever been to Costa Rica? Okay, on January 23rd, 2025, a hearing was held before this court regarding the suppression of DNA IGG. Ah, yes, that day. And Mr. Kohberger's that feels like a long time ago, Frank's proffer hearing. During that hearing, Matthew Gumet testified regarding the state's relationship with Othram, the contracting process, and specific information about the IGG work done by Othram prior to its SNP data being passed to the FBI. Mr. Gumet was involved in the original process that led to the IGG contract with Othram, which involved coming up with specifications for the scope of work for the contract. Oh, that sounds really good. Cinnamon Life with vanilla almond milk. That sounds really good. Yeah, and I mean, for those of you guys who don't know, I'm vegan, so like that what you're describing there is a vegan situation right there. Okay, pass the FBI. So he was involved, right, the contract with Othram, which involved coming up with specifications for the scope of work for the contract. Mr. Gumet specifically testified that, quote, manuals, protocols were provided back to us as part of the bid, end quote. Mr. Gumet also testified that the contract with Othram specifies that they would keep any data or other things associated with that. And so in this case, I don't know if they have other data or records that they have kept that they have retained. We asked them as part of the termination in this case of our work that they would preserve those things and that they would communicate with both the prosecutor's office and MPD if any of that information was to be disposed or whatnot. Mr. Gumet stated that protocols and procedures were received from Othram in 2021 during the bidding process he believed would likely exist. In response to the new revelations in Mr. Gumet's testimony that the state had in its possession in the protocols of the lab through the contracting process, as well as other significant materials, Mr. Kohberger filed his 22nd supplemental discovery request on January 28, 2025, requesting multiple items relating to Mr. Gumet's testimony. In its response, dated February 11, 2025, the state objected to a number of items. Shocker. For purposes of this motion, the state responds to request numbers 424 and 425, raises the specter of prosecutorial misconduct. Retro. Mr. Kohberger specifically requested, quote, all Othram lab protocols, policies, and procedures and validation studies in place in December 2022, as testified about by Matthew Gumet, as well as bench notes, electronic data files, and photographs and quality records. Water? Cereal with water? Literally never heard of that. What the actual fuck? Water? I can't even wrap my head around that. Water with cereal. Has anyone else ever done that? I don't know. That's interesting. The state objected to this request in particular as being untimely. I'm sorry. I'm like, what? I can't even picture that. That sounds awful. Okay, the state objected to this request in particular. What is wrong with why are you hating on almonds though? Yeah, no, cereal with beer. One time when I was a kid, we used to have honey bunches of oats as a kid. And one time, we always had like soy milk growing up or whatever. And like, that's usually in like a white carton, or it used to be in like a white carton this is back in the day before there were like different brands and shit. Anyway, so I was having a bowl of I was in like first grade, I was having a bowl of honey bunches of oats, and I thought I was grabbing the soy milk or whatever to pour on it. Turns out it was orange juice. It might sound good. It was disgusting. Literally, I passed it to my brother to see if he could eat it because like we never wasted food, and my brother wouldn't eat it. And then he passed it to my dad. My dad was like, nope. But my mom was the one who was like literally hating her life and ate it because we didn't waste food. It was disgusting. Just saying. Sounds good, not good. I don't know why Twiz be hating on almond milk though. Yeah, it was gross. You can too, milk a nut. Okay, so the state objected to this request in particular as being untimely and stated that the court did not require the state to produce any of the other bidding documentation, including Othram's bid submission, and discussed Othram's accreditation status, other customers, past cases, the name and qualifications of the primary genealogist, the name and qualifications of the chief scientist, and the SOPs or analytical methods that were to be used. This was the first time that defense had been made aware of the contents of the material provided for the court in camera review. Had Mr. Kohberger known, yeah, I'm fine calling it almond juice, that's fine. Had Mr. Kohberger known the materials contained the information described, certainly would have sought, they left out a word, certainly would have sought the specific listed information. Because Mr. Kohberger did not know the materials provided to the court referenced to SOPs and analytical methods, and because Mr. Nye affirmatively represented that Othram had no such documentation, Mr. Kohberger did not ask the court to reconsider. Most troubling is the last statement in the state's February 11th, 2025 objection that while the materials provided to the court for review contained references to the SOPs were inadvertently excluded from the materials. Consequently, the court was misled about the materials reviewed in camera, resulting in deprivation of clearly discoverable documentation. The state objects to the production of materials that it conceded in 2023 Mr. Kohberger was entitled to. Just 6 days later, in its expert witness rebuttal, the state provided a disclosure for David Mittelman, and we're going to cover him next. Mittelman is the CEO of Othram Labs. The proposed testimony concerns the testing done by Othram to generate the SNP profile. The proposed testimony covers the testing methods used by Othram, validation, and quality standards. All these topics were covered in Mr. Kohberger's fifth motion to compel. Almond water, yum. You guys are so funny. Feel free to list those. I'm curious what else people be doing with their cereal. So Kane shops at the Dollar Tree. I prefer Dollar General, although, I mean, I don't even know where there is a Dollar Tree or a Dollar General where I live. But where I go to the Dollar General is when we're at the Outer Banks at the beach, because like that's the store you go to. The Dollar General be popping. That's like the where all the cool kids are at, or whatever. It's like, you know, it's like the, what's the word I'm looking for? I can't think of the word. Anyway, okay, argument. So due process. Okay, let's just see. So a lot of this, again, we've seen it's just a lot of the same in all the things. The duty of a prosecutor to turn over evidence. Okay, so usually the only feasible remedy is dismissal of the prosecution or suppression of evidence that would have been impeached. Or a lot of overlap here with Karen Reed as well, right? Like hint, hint, lolliport videos, right? What you got against Dollar General? Dude, their plastic bags are the shit. I've talked about those on various live streams before. And I think it was Meg P who also was like, yes, I second that. They're the best bags. So like at the Outer Banks, that's like the only store, unless you want to drive like 45 minutes to get to the actual grocery store. So the Dollar General is like the lifeline in terms of like it's close nearby, unless you want to drive 45 minutes. Which like if you're at the beach and it's nice weather, like who wants to do that? You know what I mean? 45 minutes each way, by the way. So, Twiz knows the story. He knows the inside scoop. Well, now I want to know. Okay, Mr. Kohberger is now asking for the remedy of exclusion because at this late date, he will be unable to investigate the impact of the evidence itself, as well as the consequence of withholding such evidence. So they're saying, so basically they're basically citing like a discovery violation. And I'm sure this will come up again when we get to the big N, as I've been calling it. I know Twiz is excited for it, the big motion for the death penalty there. In this case, the question of whether state has withheld or concealed evidence specifically requested by Mr. Kohberger is evident in the record. And then we're getting to Brady. Okay, Brady violation. All right. All right. So that's why. Okay. Okay. I think also too, though, in terms of why the state or why the defense, like if the IGG is coming up in the trial, which I was thinking it was going to, I thought the defense actually was like using that as a strategy. Clearly, they have plenty of pathways, right? Although the state filed that motion to eliminate that we just covered, trying to preclude those pathways. But the defense has a lot of pathways in which they can use this, I think, to their advantage. However, now that I'm thinking about it again, because of course this is their motion to eliminate to have it excluded, I think it's twofold. They're doing this on the grounds here of Brady violations, right? Why? Because their goal overall is to get is coming up in the big death penalty motion, right? They would rather that is what they would rather than IGG coming in at trial. They would rather ask to have it, well, they already asked to have it suppressed, but they would rather have it file this motion to eliminate and, citing the Brady violation, for example, because this is the first part we've seen here. In other words, in order to support their subsequent filing to try to get the death penalty taken off the table. That is their ultimate goal, right? But also to that, I just thought of another thing, which is this. If they can keep the IGG out, then the state has no case. Like, how are they going to, like what we were just talking about, right? Like, how is the state going to show the jury, like, what the fuck are they going to show the jury as to how they got to Bryan Kohberger, right? Like, it's, the state will be pretty much screwed. I mean, more than they already are, I would say, if they can't get into the IGG, which now it makes sense as to why the state was asking to include it in the defense. It's so funny because it's all flip-flopped, right? Initially, it seemed like the defense wanted it in and the state was trying to keep it out. This is very interesting. This is like, I think maybe a bit of gamesmanship to a certain extent. And I think there's a lot of strategy here, and I'm going to keep thinking on this as we go through. Why is Twiz hopeful? Yeah, totally agree. Hope is a good thing. I don't know where Twiz, are you there? Why is Twiz too hopeful? Oh, you're probably referencing some of these documents, I would imagine, right? Or are we referencing stuff with the cell phone? So, okay, here's the thing. Remember, oftentimes when it doesn't matter if it's the prosecution or the defense, or it could be in a civil case, right? Plaintiff, defendant, people that are filing these motions, this happens all the time, whether it's oral argument or pleadings, okay? Keep this in mind. Their grounds, the grounds on which they are like moving the court to do something, to take an action, right? May not necessarily be the reason they're asking for it. That's kind of my point. We see this all the time. There's more to it than that. Maybe sometimes it is literally what is because of what they're saying, but a lot of times it's not. And I feel like there's just so many recent examples of this, but that's kind of what I'm saying here too, is like, I do here, yes, Brady, yeah, because they want the death penalty, but also, right, it's clear now that the state is pretty much going to be screwed, and that's why the state is filing a motion in limine to include it. So it's like, because the state's going to file a motion in limine to include it, the strategy there is you're going to do the opposite, right? Because that's what you do. And so I think at this point, they've realized, like I was just saying, the defense has realized that the state's going to have a hard time presenting their case to the jury if they can't explain the IGG and how they came to Bryan Kohberger, right? So while they're not citing that as a reason, they don't have to. They've got plenty of other reasons as grounds for this motion in limine. But there can be additional reasons, is kind of what I'm saying. Twiz, are you working on your what was it? Desper or whatever. I can't remember. I'm trying to think of how you typed it. Because now that's what I call display from now on. It has been renamed. Yeah, no, and there's definitely more to it. There's way more to it than what meets the eye. And that's the thing. Whenever you've got something where you can say there's a Brady violation, right? That's always the grounds you're going to use, even if your main motivation is something completely different, right? Because this is always going to be your strongest argument, no matter fucking what. Okay, so Brady violation. The basic tenet of Brady stands to this day. The suppression by the prosecution of evidence favorable to an accused. I think we kind of know what Brady is, hopefully. Any of you guys not know what Brady is, then I don't even know. Here, Mr. Kohberger repeatedly requested materials related to IGG, and the court found that he had made a showing of materiality as to the records sought through discovery requests and motions to compel. That's interesting. I'm curious why, Kane. Speaking of grounds. The court held 2 hearings. Yes, indeed. Issued an order explaining that Mr. Kohberger had established sufficient evidence. Right. I think they already referenced this. The focus of the order was on the second bucket. Oh my God, why are we saying bucket though? Please, let's not ever say that word. Bucket will never be the same for me ever again. Ashley Jennings ruined it. Completely ruined it. So, by the way, we have an emoji for her. Anyone that feels so inclined, for members, you guys have access to it just because that's what YouTube does. If YouTube made it available for everybody, everybody would have it, but that's just what YouTube does. In fact, I can't even use them. So that's why I always compel you guys, because I'm like, you know, living vicariously through y'all being able to use the emojis. Okay, so identified by both Mr. Kohberger and state, knowing that according to the state, the rule only requires a disclosure of the results of the report themselves. The court then conducted an in-camera interview of the totality of the IG material provided by the state concerning the construction of the family tree. I'm concerned about it. Questions by Othram and then the FBI. Show it again longer. Okay, you got it. That's what she said. There she is. Just when I see that, I'm like thinking, you know, like that crazy circus music stuff. I think Anne does a great job. I'm curious though why you think that. That's very interesting. I don't think that I've heard anybody say anything bad about her, actually. Usually even people that come in here sometimes that seem to be kind of like, I don't know, I don't like characterizing people, so I'm not going to. Yeah, I'll just leave it at that. Like, I feel like I don't think I've heard anybody say anything. I'm just curious. I'm not saying you're wrong. I'm just curious. I mean, I think I love talking about lawyering. As you guys know, like actually somebody just the other night was asking me, I think it was last night. Who was it? Bunny was asking me. She was like, what is your opinion in this case? And I was like, my opinion on what? And she was like, of what happened. And the way I understood that to mean was like, of what happened that night, right? Like what actually happened. And I was like, I have no idea. We don't have any information. I was like, which I actually enjoy because I literally am able to just objectively critique and assess the lawyering, which I love. I love, the lawyering. So that's why I'm curious. Need some Z's here. Awesome. I'm curious. You guys elaborate if you feel so inclined, please. Right. What could she do better? That's right. Because I think this is a great, I mean, I'm so all about discussing lawyering. So if you guys, I'm so curious. We don't want to ever miss an opportunity for good discussion. Okay, so there's one thing here. Okay, so you're saying the change of venue. Well, I mean, one thing I will say that gets overlooked, I think, in the order for the granting the motion to change venue is that apparently the Latah County Courthouse physically could not have possibly had the trial there, which is interesting because it's like, well, then why was there so much ado about it? Like literally they didn't have the space. They don't have enough staff. Like it was like impossible. Right. Regardless of anything else. So there's that. Yeah. So Tonka says, I think she's speaking of her. So I would say that her strongest, here's what I will say. Where I thought she was the most brilliant in oral argument was, unfortunately, is before I was covering this case, but I was, of course, following it, but I wasn't covering it. And that was early on. There was those hearings right around the time they were supposed to go to trial initially, and it had to do with the speedy trial. And I wish I could remember exactly what it was. There was so many layers of strategy to how she did that. It was mind-blowing. Absolutely mind-blowing. It was really interesting. There was so much strategy there. And that was really, 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 really where I was like super impressed. Like, wow, she blew me away. But that was so fucking long ago. And I don't remember specifically the ins and outs because it was really like layered and complex. But yeah, as far as like, I will say I was underwhelmed. I personally was underwhelmed in the January hearings. Did they have any hearings in February? I can't fucking remember. I don't think they did. Yeah, I was underwhelmed. I mean, and if anybody it wants to, like, I'm such a nerd, right? Like, this to me sounds fun. The thing I'm about to mention sounds fun to me, but I don't know if it would be fun for you guys. So let me know what you think. But I would could do a stream where we go back and watch her oral argument from like the 23rd. And you know, we've watched it a bunch of times, but instead of watching it for the new information, because at this point we know, watching it literally from the standpoint of like analyzing her argument and what I think maybe she could have done differently or done better, or, you know, saying what I think she did great. You know, it's kind of like whenever, you know, as you guys know, I'm a violin teacher, right? It's kind of like when you're teaching a student, right? You always point out the things that they did really well and then things they could improve. So similarly, right? But in other words, we could totally watch it and go through it. And I love thinking along those lines. Like when I'm watching a hearing or a trial, that's what I'm thinking the whole time, is I'm thinking about the lawyering. And that's true. That's true. But still, even still, it's always nice when you see brilliant oral argument. You know what I mean? I'll tell you who just first thing that came to my mind in terms of recent memory for like really brilliant oral argument where you usually don't see it is Mr. Mason in the Casey Anthony trial on the motion to dismiss. You guys know how I get emotional just thinking about it. So I'm just going to, yeah, incredible oral argument there. But anywho, yeah, she's done well with the cross. It's going to be really interesting to see her at trial. That's for sure. You know, because that's a great point. Like in terms of her, you know, what do defense attorneys usually, what's super important for them is cross-examination, right? And so far we've gotten to see a little bit of that, but not that much, right? I mean, usually we don't really get a good look at that until trial, usually, right? Anyway, so I'm really excited to see that for sure. Yeah, the thing about the Franks is they kind of put all their eggs in one basket, you know, because the whole thing was the fruit of the poisonous tree, which is a good strategy per se. That's kind of the whole point, right, with the Franks, right? When you looked at the motions to suppress and then the Franks, essentially what that says to me is like they thought their strongest motion to suppress and their strongest issue, period, was the IGG. And so that's why the Franks was really about the IGG, and then everything else stems from that. So it's kind of like, again, all your eggs in one basket, where if it fails, then everything fails, right? And it was a tough one to make because, again, there's not a lot of case law. I mean, that's what it comes down to. Fast forward 10 years in the future, if this trial was happening, there could be a wealth of case law to back up her argument. And that's the problem, right? That's how it goes, right? Whichever side can provide the most case law on point. Now, there are exceptions. For example, take Karen Reed, because the Commonwealth, like Hank Brennan, does not do anything with case. Like, anyway, usually that's how it goes, right? Whoever has the most point case law wins, essentially. So when you're dealing with a novel issue, obviously you don't have that, and that puts you at a disadvantage. So I guess one could say maybe potentially if the thing that keeps her up at night right now, you know, if she's like reflecting, well, I'm sure there's a lot that keeps her up at night, but if the thing that keeps her up at night is in the past, it might be, should I have, you know, relied more on a different issue, like maybe the Elantra, for example, right, versus the IGG. Like what maybe a better strategy could have been, with all the different, you know, motions to suppress, find the one where you've got the best case, the strongest case law, and rely more on that. Because with the IGG, that clearly was going to be the weakest in terms of the case law, even though it was a really strong issue in my mind. But in terms of how it works legally, if there's not case law, yeah. Right. So there's a lot of overlap. the thing about Franks is it's what they're asking for, right? It's what they're moving the court to do. So in Franks, they're moving the court to conduct an evidentiary hearing. With a motion to suppress, they're moving the court to suppress the evidence. That's it. But they go hand in hand, as we saw. And for motions to suppress, there's different grounds for that, as we saw, right? For Franks, the added element there is law enforcement making a false statement. In other words, it's more narrow in that regard. Like it's a false statement on an affidavit, right? Or sorry, search warrant. So a knowingly or recklessly false statement. So misleading the magistrate essentially to get a search warrant. But as we saw in the motions to suppress, issues with the search warrants, such as misleading the search warrant or misleading the magistrate, right, were also used as grounds for the motions to suppress. So there's a lot of overlap as well, if that makes sense. Like, for example, the thing about where it's like one person signed the affidavit, but there was, Brett Payne's affidavit, that type of thing, right? That was used as grounds for different motions to suppress, but it was also incorporated into the Franks, I believe, because technically it's like making a intentionally false statement. If you're like, this is my affidavit and it's not, right? So, yeah, I'm curious, what are your thoughts on this comment? Twiz, what are your thoughts on this comment from Tonka here that I've got on the screen? Tonka says, Anne solidly nailed 4 of the requirements for Franks, but she didn't focus on legal violations concerning the CAS data, how it was processed. Yeah, that's a good thought. And I mean, I'm sure Twiz probably has something to say about that because I know he's like all about that bass, whatever the song is. Anyway, I appreciate you guys though that are being a little bit more critical of Anne because again, I'm always assessing the lawyering and I like being able to have the opportunity to talk about strengths and weaknesses of any attorney, right? And I think it's important. I think it's important to point out that, where she could do better. I still think she's phenomenal. But again, I do think that, and again, like at the hearings there, those were strategic decisions made ahead of time. And that's one of those things, like, again, she could have maybe chosen to do that differently. And hopefully need some Z's. Hopefully that I answered your question to that where it makes more sense about the overlap, the similarities and differences, right? But there's a lot of overlap, but there's some differences with the motions to compel and the Franks. But so Twiz is saying wouldn't matter because it wasn't going to, and that's a good point because as we heard, they could remove everything. I mean, look at who's on the screen right there. They could get rid of everything and they still had probable cause because all that mattered was the DNA on the sheath, right? That was really, at the end of the day, that's what it was, right? Sadly. Oh, it wasn't a question. Okay. I guess I think you said, like, correct me. I know. I took it. Maybe it's because I'm a teacher, right? I understood it as a question. But also I'm just thinking out loud as we're talking about it anyway. But another good comment here, too fast for fleas. I think Anna's toning it down with Hitler at the moment because she's asking for his decisions on things and being nice. I think when the trial comes, she'll be, but I have no doubt about that part for sure. Yeah, that she'll be a bulldog in front of the jury. Yeah. Yeah, and I guess also too, you guys probably can tell already, just because again, it's like the teacher, like my teacher brain is like, whenever there's like, oftentimes there's like a question and it's like, I'll read or comment, right? And I interpret things as an opportunity to try to explain something, because usually there's going to be somebody, right, that maybe doesn't, I don't know. It's just, like, I don't know, like if, for example, if a student is like, is that the right note? And I could say yes or no, I will never answer it that way. Instead, I will have them figure out, we will talk it through and then make sure that they understand it. And like, I don't know, just, it's like the full thorough thinking it through of things, if that makes any type of fucking sense. Yeah, so. Yeah, that's a good point. When you play dumb, people expect less. Although I don't think anybody thinks, well, I think that would be dumb for people to underestimate her, I think. But I do totally, that could be a strategy. I think that maybe I think maybe it's too late for her to employ that strategy with this particular case because she's been working with these attorneys for so long. But yeah, that is true for sure. Okay, so okay, the state provided test results in the form of two large text files. Okay, here we go. One identifies being the data produced by Othram, and the second as the data produced by the FBI. Still not having received the promised material regarding the SNP testing conducted by Othram, Mr. Kohberger renewed his request for the material in his 15th supplemental discovery request and filed his 5th motion to compel discovery. A hearing was held in the Latah County District Court on May 30th, 2024, during which the state reiterated that Mr. Kohberger was entitled to the requested material, but that material did not exist. The requested material was laid out in Exhibit N. Didn't we already read this, or are they just repeating it? I mean, I remember reading this. I literally remember reading this. Did I scroll back on accident? I mean, we read all this. I remember reading. Okay. I think what they did was they had it included in the facts and then they repeated it here in their argument section. So, okay, this objection is incomprehensible in light of the state's concession that the material requested in request 424 was for materials that the state has repeatedly conceded were discoverable under Rule 16b-5, and assuring the court on May 30th, 2024 that the state understood its obligation to produce the material. Not until February 2025 did Mr. Kohberger learn that the state had possession of minimally the SOPs and protocols requested in their 5th supplemental motion to compel. Right, because we're in the category of Brady evidence is what we're doing. Right. Why did the state not alert the court at the hearing on May 30th, 2024 that in part the materials sought by Mr. Kohberger were included in the material provided for in-camera review in October 2023? And most troubling, why did the state represent that the materials from Othram did not exist when in fact some of the materials requested were in the possession? Speaking of assessing lawyering, I would not do it like this. I don't like the idea of asking this question, and here's why. Oh, you guys can't see this. Oh my God, let me get rid of her. Hold on. Jesus Christ. All right, I highlighted it. So here's the thing. So asking this question, I'll read it again. Why did the state not alert the court at the hearing on May 30th, 2024, that in part the materials sought by Mr. Kohberger were included in the material provided for in-camera review in October 2023? And then there's another question, and most troubling, why did the state? So when you're asking the court a question, and the question is like, why did the state what you're doing is you're giving the court an opportunity to explain why the state did what they did. That's not what you want to do. I would not be asking this as a question. I would be making an assertion. The state did not alert the court at the beginning, right? In the affirmative versus a question. I mean, for a number of reasons. Like again, it's going to give the court an opportunity to come up with an answer to justify the state's actions, but also it's not as affirmative. Anyway, okay. So speaking of assessing lawyering, and most troubling, here's another question. Why did the state represent the materials from Othram don't exist when in fact some of the materials requested were in possession of the Latah County Prosecutor's Office? Idaho rule of professional conduct requires a lawyer not make false statement. Well, if you're going to make this assertion that there was a materially false statement, you have to do it by requesting sanctions. So don't just say this. Don't just, I don't like this. I don't like this at all. judges, I think judges don't like this either, in the sense that if you're going to allege that somebody, like we just saw, again, thinking back to Karen Reed, we've just seen a lot of this recently. Y'all know hopefully by now what a big fucking deal this is, right? If you make a false statement to the court, you can't just say, like, if you're going to say that, you need to follow that up with like sanctions, right? Or motion for sanctions. Anyway, maybe there is one somewhere and we haven't seen it yet. I don't know. Just, okay. In addition, the state seems to imply that Mr. Kohberger had a duty to ask the court to reconsider the decision regarding the material review in camera without knowing that the materials sought were contained in the reviewed materials. It's a bit redundant. Something the state now acknowledges and did not disclose. As noted in the state's response, not only was the SOP itself inadvertently not provided for the review, but the inventory supplied to the court and Mr. Kohberger listed the materials in the most generic terms as ISP Othram contract documents. Okay. The state's response appears disingenuous. Hiding the material. Okay, I'm kind of over it with this document. Let's see if there's anything else interesting. I mean, a lot of this is kind of your boilerplate. I mean, we've had faith. If you're gonna allege bad faith, you need to like you need to fully do it. You know that saying, don't come for the king if you're not gonna whatever the fuck the rest of the saying is. Okay, let's move on. Oh, that's from Bicka Barlow. Interesting. Okay. Yeah, it's funny. I thought as I was reading it, I was like, I wonder who wrote this, because I'm like, that voice, the voice in that document, I was like, this is a different voice than what, because usually I can read these and tell who's writing them. I was like, huh, interesting that was Bicka Barlow. Okay, that's who wrote that one. All right. Mittelman. And then we have the big one. So this is a short one. So here's the improper expert opinion. Oh wait, no, we need to do the other motion in limine first. Okay, improper opinion testimony about Mittelman. So we referenced this earlier. On February 17th, 2025, the prosecution submitted the disclosure for rebuttal witness David Mittelman of Othram Labs. In the disclosure, Mittelman offers multiple opinions as to the quality of the work done by Othram Labs in generating a SNP profile and for starting the IGG search for relatives of the S&P profile. In addition to these opinions, so interesting, right? Remember how they just did this? Okay. The whole thing about, is the IGG going to come in or not going to come in? Remember we were talking about strategy? The prosecution has a rebuttal witness. This guy from Othram. The only way you can do that is if they are anticipating the defense in their case in chief to call witnesses related to IGG. So that's interesting, right? In other words, it's like they must have expert witness disclosures and be intending to call people about IGG as experts in their case in chief, yet at the same time, they're filing a motion in limine to exclude the IGG. Fascinating, right? Like I said, there's the strategy to it. So, okay. In this disclosure, Mittelman offers multiple opinions as to the quality of the work done by Othram. In addition to these opinions, he offers objectionable opinions that fall outside the proper role of an expert and are highly speculative. So subsection A, Mittelman should be excluded as a witness based on failure to disclose in a timely fashion in due process. Okay. So I'm not going to worry too much about this. This is just basically they're saying it was discovery. But I do want to read this part though. Okay. Oh, it's already subsection B. There we go. Subsection B. That was subsection A was short. Okay. The state offers the following opinions. Mittelman will testify that the collection of DNA evidence from the crime scene, the development of an SDR profile, and its entry into CODIS all took place before Othram's involvement in the case. Interesting, because as you guys have seen on the state's IGG tree, DNA tree, Othram was first before CODIS. With an SDR profile already in CODIS, identifying the suspect was ultimately a matter of time. Othram was engaged to build an S&P profile and perform forensic genetic genealogy to accelerate the investigative process. While this approach expedited the identification, it did not change the inevitable outcome. The suspect would have been identified regardless. How? How? Ask, genuine question, how? How would he have been identified regardless? Or maybe, I mean, let me be clear. How would the same suspect have been identified regardless, if not for IGG? Literally how? No, explain that to me. I cannot think of how that would have happened. The FBI's role may have further accelerated the work Othram had already begun, but Othram was on track to reach the same conclusion. This is evident from the preliminary incomplete report Othram provided after being asked to stop its efforts. In this case, additional reference testing was always going to lead to the identification of Mr. Kohberger, regardless of which agency completed the process or when it occurred. All the above opinions are improper because they're highly speculative. Okay, the first opinion seems to assume that at some point in time, Mr. Kohberger's DNA would be entered into CODIS. The only way into CODIS is via the commission right or conviction for a felony. This assumption is improper, right? Not only are they, okay, again, with the highly speculative. As the disclosure sets forth, Mittelman would testify about his lab, their processes, and their quality system. The speculative opinions add nothing other than confusion and will result in undue consumption of time. That's basically it. Okay, that I don't think there's anything really there. Okay, so next up, another shorter one, relatively speaking. So this is this is the DNA under the fingernails. I almost said fingertips. Okay, statistical analysis. Please read slower. Okay, I can. Sorry, I'm a fast reader and a fast talker. I'll read slower though. I need to drink some water too. So an order limiting the moves the court for an order limiting testimony about the statistical analysis of item Q13.1. Fingernail scrapings. All right, allowing such testimony would violate, okay, we know. That's always going to be pretty much the same. Statement of facts. In grand jury testimony, Jade Miller testified as to the results of testing done on item Q11, the sheath strap and inner strap. The statistic reported by the lab is a likelihood ratio. Miller testified that the likelihood ratio compares the probability of the evidence, meaning the DNA profile obtained, and comparing two different hypotheses. So again, I've referenced this before. I thought it was really fascinating. We learned a lot about this again in a recent Casey Anthony episode where they had the dude from the Netherlands who I've talked about before, who's like an expert at trace DNA, contact, transfer DNA, and all that, like what we were reading about last night. And what was really interesting was that he explained very well, I think better than I've heard anybody else explain in any trials that I've watched, at least that I can remember offhand. One thing that he explained very well, that was a big distinction in my mind that I took away from it, was about the part about the hypothesis. Because that's really interesting. That it's just, they just get, it's just a hypothesis, right? Like it's a word that I don't think I'd ever even heard being used when it comes to DNA, but that's what it is. But so it's interesting. So we're seeing it again here. I just appreciate that it's being brought up, period, because it's kind of like, I feel like it's how they work it. It's how these DNA analysts do their job, but they don't always use that word in front of the jury. And I bet you guys can imagine why. And I feel like they should use that word in front of the jury. Because, you know, people think that DNA, I mean, right? Well, they're going to think this until they know or otherwise, but it's just like it's a done deal, right? It's 100%. And to understand how it really works, and that literally it is a hypothesis with a likelihood ratio, at least now you're getting a better understanding of how to process the information and the data that they're giving you. Right. Yep. I go too fast still? I'm not even reading. I'm just talking. That's, I'm trying to go slower. Okay. Miller reported the statistic for this comparison, but the state posed the following question to Miller, and it's redacted. From Miller's answer to this question, it is clear that the comparison to the world population is not an appropriate or scientific way to discuss the likelihood ratio. Argument. The use of misleading language confuses and misleads the finder of fact and is barred by rules 402, 403, as well as due process. The erroneous admission of irrelevant and prejudicial evidence, right? Again, a lot of this is the same as other things. Here, expanding beyond the language of the report would prejudice Mr. Kohberger in that it might allow the jury to infer that the inconclusive data, okay, right, yep. We've seen this in plenty of trials too, right? Where it's inconclusive. And what I think they're probably going to be getting to here is like a jury can take away from inconclusive that's like, oh, well, that person could be the dude, right? But the real takeaway should be it's inconclusive, which means they can't prove it was him, right? Let's see what they say. So allow the jury to infer that the inconclusive data would mean that he might be included. Oh, yep, there it is. Keep reading. There it is. Yes. This is very similar to other things, like, for example, with Richard Allen, right? And like the tool mark analysis, similar type of thing. And I've given examples about this on other live streams as to how the way that experts use this whole thing about inconclusive or can't exclude is interesting. And I guess that's being kind. It's really kind of misleading. Jose Baez, by the way, does a great job of pointing that out for the jury, by the way, and making sure that they fully understand what the fuck these words mean. Later, what wasn't? Who's Trish? But it wasn't inconclusive. Well, I don't know. It says inconclusive. I'm just reading what's on here. The inconclusive data would mean that he might be included. Likelihood ratios are different from traditional statistics that courts and juries are used to seeing and hearing. The likelihood ratio is a comparison of hypotheses. Yup. It is not a statement of identity or probability of identity. It simply asks the question, given the data, which hypothesis tested is more likely? Yep. Again, we heard this explained really well with that expert in Casey Anthony's trial. The court should, we don't have a Yoda command. It's funny. I love, though, that people just like try these different commands. I love it. It's great. The court should exclude questions in testimony such as that described above. Clearly, Miller disagreed with the premise of the question. Her answer, that the likelihood ratio was not that type of statistic, indicates that the question itself was based on a misunderstanding of the meaning of the likelihood ratio. As Miller describes in her testimony, the likelihood ratio is a comparison of two hypotheses, not a statement of rarity of the profile or probability of finding the same profile in the population. This type of question could potentially confuse and mislead the jury and required an undue consumption of time and cross-examination. What are you guys referencing that things are not? I don't know what you guys are talking about. Oh, okay, maybe you're referencing this. Which motion in limine is this one in, Tonka? The 399 profile? I don't know that we've covered that document yet. And then there's the conclusion, fair trial. Yes. Agreed. Could not agree more. Yeah. And again, Jose Baez does a phenomenal job. Like, dude, the way he handled that in Casey Anthony's trial, where the state's DNA, experts for every field, but like any expert, right? Whenever they were offering something and it was the same type of thing of like likelihood ratio or inconclusive or whatever, the way he handled that, I just love it, because he doesn't do it in like a bulldog way. He does it in a way that is so like he's joking with them, smiling. They're on his side. He's like their friend, and he's like joking with them, and he's joking like, so you're saying this, but you really mean that, right? And then they're like, yeah. It's just awesome. I love it. It's great. Okay, so now let me find the next one. Boom, boom, boom. Another one bites the dust. Boom, boom, boom. Another one bites the dust. Boom, 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 boom. Okay, hold on. I can't do that and read this at the same time. I'm looking for the thing. Hold on. There it is. The biggin. I can make the type bigger for sure. Definitely. Yep. Totally. It should be with this set of documents. It might be in the other one. Like, I think there's another motion in limine. I think I know what you're talking about, Tonka, but I wasn't planned on doing that one tonight. That's interesting because I'm standing still at my computer. Okay. Okie dokie. This might be a bit. I think we need to do it here. Okay. All right. Here we go. Defendant's motion to preclude the death penalty and adopt other necessary procedures due to the state's numerous disclosure violations. Okay. The state has failed to provide expert disclosures that are specific enough to understand what testimony and discovery it intends to rely on, depriving Mr. Kohberger of the ability to conduct independent review and investigation of the evidence it will rely on. Get redundant with the rely on part there. Additionally, as counsel has previously stated, the discovery in this case has been provided in a manner that is as though the state took tens of thousands of documents, photos, and clips and shook them up in video clips and shook them up in a snow globe. I am not a fan of that. What do you guys think of that? I'm not a fan of that. You know, there's different trials, right? And there's different courts. When I say court, I mean jurisdiction, but also specific judge, where the tone and tenor of the pleadings and oral argument and attitude between counsel is like spicy as fuck. And every document back and forth is going to be starting out with something like this. Now, what I will say is, while it is warranted in this case, that is not really how it seems like. It seems like, okay, my interpretation of how it's done in Idaho is much more reserved, and they save these like hyperboles, if you will, for like the great biggest atrocities, right? You know, a good example too, when you look at like things that are like civil cases, right? You know, EDBL says like, you know, a lawsuit is just allegations and shade, right? It's like, that's what it is. They're all about, it's just the dramas and the pleadings, and it's like the spice, and it's like from the get-go, it's like they're saying this stuff, and it's just like these crazy, and it's funny and entertaining in a way, right? But in criminal cases, and especially in certain courts, you don't tend to see that. Anyway, I just don't know that Judge Hippler will appreciate that. That's kind of the point that I'm going to make here, is like, you have to know your audience. Judge Hippler, I don't think we've ever seen him laugh. I think maybe once we've seen him laugh. He doesn't really smile. I don't see him taking kindly to this. I don't know. Shook them up in a snow globe. I mean, okay. While defense counsel has made her, oh, wow. Yeah, continues on. Herculean efforts to review the discovery provided. Oh, boy. I just don't know that this judge is going to like this. There's no possible way that all of the discovery, which is equivalent to 68,000 copies of the Encyclopedia Britannica. Now, this I appreciate. Why? It's an actual, like, number, right? Versus just, like, where was it? Tens of thousands or whatever, right? Just like an exaggeration. Like, this actually is at least more helpful. I think, more specific. And there's a footnote. A single Encyclopedia Britannica contains more than 30 volumes. Okay. Can be reviewed prior to the trial date. Who is a giant? Okay, so Tonka, do you want me to go looking for this here? So you referenced, where is it? $399. Okay, hang on. No scroll left behind. I bet it's in, I think it's in one of the ones we haven't done yet. I bet it's in this one. I bet it's in this one. I bet it's in this one. Inclusive data. I bet it's in this one. How much you want to bet? Wait, no, we did this one. Did we do this one? No, we did this one. We did this one. It's not this one. Never mind. No, wait. Oh, they're very similar. No, we didn't do this one. Yeah, because I was like thinking, I thought it was statistical analysis. Yeah, that's the one we read was statistical analysis. This actually, I think, is the one I meant to do, or maybe I meant to do both. It's funny because they're so, why are there two? Hold on, let me just see. Why are there two? I know they're supposed to go together, right? Because there's like, yeah, it's number 5 and number 14. Okay. So that makes sense. So we'll come right back to the big one, as I keep calling it. But so this is the one we just read. This is number 14, the statistical analysis. They kind of go together. And then this is number 5 here. And we did not do this one. I think this will close the loop on the things. I will make it bigger. I'm just switching between documents. So don't hang on. I'm not even reading it yet. Okay. This is the one I didn't do yet. So it's got to be this one with the blackouts. Here, let me make it bigger. That's what she said. Okay. Let's just go through this and make sure. So this, because we did number 14, we didn't do number 5. So let's do number 5 and then we'll go back to the beginning. So this is the inconclusive data. Okay. Finger scrapings, right. Jade Miller again. So this is the same as before, the likelihood ratio, because, right. Okay, the statistic, the likelihood ratio was calculated assuming that Madison Mogen was a contributor to her own fingernails. Miller testified that MM as followed, redacted. The data from the sample was redacted as to Mr. Kohberger. Miller testified that inconclusive means that an analyst is blank or redacted. Miller went on to explain that the likelihood ratio for Mr. Kohberger, redacted, argument. The use of, okay, this again is the same as the other ones, just fundamentally unfair. Okay, here expanding beyond the language of the report would prejudice Mr. Kohberger in that it might allow the jury to infer that the inconclusive data would mean that he might be included. So this, again, this is actually the same as the other one, but then it changes. Okay. Here. So when the lab generated an LR laid out above, the hypotheses tested were Madison Mogen, Kaylee Gonzalez, and one unknown unrelated person versus Madison Mogen and 2 unrelated persons. The comparison was done for all of the individuals listed in report number 7 and for Mr. Kohberger in report number 26. At the ISP lab, any number greater than 100 is considered a conclusive result indicating inclusion. Any number less than 0.01 is considered a conclusive result indicating exclusion. Thus, if a likelihood ratio falls within the range of 0.01 to 100, the lab cannot draw any conclusions and the data is reported as inconclusive. In her testimony, Miller did not provide a full context to the analysis. The lab reported a series of likelihood ratios for item 13.1, including a likelihood ratio, there it is, Tonka, of 0.399. There you go. No scroll left behind, I will say. So 0.399 for somebody, 0.485 for somebody. These are all redacted. Obviously, you guys can see. 0.2, 0.0233. So what this means then is that these are all inconclusive, right? Lab report number 7. Okay, that's just the citation. All of these individuals sit in the same shoes as Mr. Kohberger, namely that the likelihood ratio is exclusionary, but falls in the range of inconclusive. Of interest is that when the likelihood ratio was calculated for blah, 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 thus Mr. Kohberger's inconclusive likelihood ratio is similar to almost every other person for whom a likelihood ratio was generated, and focusing on his inconclusive. Okay, this is good. I like this. I like this a lot. In that it implies, this is an incomplete sentence. I cannot. Oh no, why are we doing incomplete sentences? Look, I'm going to read this as it states, as it is here, and then I'll correct it. In that it implies that the LR means that Mr. Kohberger's DNA might be present in the sample. Not a complete sentence. What it should have done is there should have been a comma after the word jury, or you don't even need a comma. You could just not have a comma, but this should be in the same sentence. Focusing on his, so you guys can see it. So in that it implies, see that this is like a clause. Anyway, whatever. How many times I'll do your proofreading for you guys. All right. So the court should exclude testimony such as redacted. More importantly, Mr. Kohberger has disclosed that through further independent laboratory testing, he's eliminated as a contributor to item 13.1. Hang on. So that, interesting. Right, the fingernail scrapings. Okay, the fingernail scrapings. So through further independent testing, he's eliminated as a contributor. So what I'm taking away from this is this, that when the state did all their testing, right, as far as the fingernail scrapings are concerned, so 13.1 is the fingernail scrapings, that he was inconclusive. What the defense is saying is like, he's inconclusive, but so are, there were several other people, right? But with further independent testing, he was actually eliminated, which would mean that with the other people that tested it for the defense, I guess, right, that the ratio, where was it? The range had to be less than 0.01. So they got a different result, is what they're saying. Interesting. That'll be really interesting to see on cross-examination, how that goes. So that is very interesting. So they're saying, because our expert tested it or whatever, and he found given that likelihood ratio, he should be excluded. When the state did it, it was inconclusive, which puts him on the same boat as all these other people. So therefore, you should exclude this. Okay. Yeah, I think it's valid. What will the court do? The court will probably deny it because that's what they tend to do. But I think it's I think it's, what I think that Judge Hippler might say, and I would actually agree. I think it's good fodder for cross-examination. I think that I think this is important, and there's going to be a lot that we will hear and the jury will hear about how this works. So the state argued, okay, sorry. When Mr. Kohberger sought to overturn the grand jury indictment, he argued that Miller's testimony was inadmissible and misleading. The state argued that the testimony was presented to the grand jury as exculpatory and an effort to elicit favorable evidence for Mr. Kohberger. Interesting. That is a very interesting argument. I'm going to read that again. The state argued that the testimony was presented to the grand jury as exculpatory. So what they're saying here is, Judge, so I might be eating my words here. They're saying, Judge, look, even the state was saying they presented this as exculpatory evidence. So that's a really good point. That's a really good point. That works in their favor. Yep. And an effort to elicit favorable evidence from Mr. Kohberger. Interesting. The independent lab testing related is indeed exculpatory. Typo there. That should be one word. He's excluded. Okay. So you know what? If nothing else, the state would be hypocritical, right? And like, you guys know how I feel about that, because the state said it was exculpatory. So yes, this should not, let's do that correctly then. Okay. Good. So I feel like we have gotten to close the loop on that one. Right. Okay, so we're back to the Herculean efforts in the Encyclopedia Britannica. All right. Indeed, a defense expert informed counsel would require 3 additional years to review all of the discovery from the 67 electronic devices and digital data alone. By providing discovery in this manner, the state is failing to comply with their obligations under Brady v. Maryland. These cases require the prosecution to provide exculpatory and impeaching information to the defense, including any information that would tend to mitigate the punishment, even if it is not constitutionally material, in a manner and time frame that it could be reasonably relied upon in preparing for trial. As discussed in this motion, in cases with enormous amounts of electronic data, the prosecution does not meet that standard by providing discovery in a manner that effectively buries exculpatory, impeachment, and mitigation information. So we've talked about this before, even recently, where this is a thing that they'll do. They'll be like, here, you want this discovery? Here you go. And then they turn it over in like, you know, a pile where you can, you know what I mean? It's just the thing that they do. And it's one of those things that's really annoying because there's really not a rule about it. Like, in other words, there's really not a rule that the prosecution has to, like, they have to turn it over, right? But they don't, like, you know, unless there's like a specific order from the court, like as in that specific judge, they don't have to like organize it a certain way. I think they should do that anyway. And some offices, like as in like, you know, prosecuting attorneys' offices, some do. Some make that their policy that they're going to do that. Why? To prevent issues. I think it should be done. I think that's the right thing to do. Make it to where they can find the things they need. Like, let's not be playing games. Okay. Unless we're playing like Clue or Shoots and Ladders or Hungry Hungry Hippo. Timely and meaningful disclosure is indispensable to the effectuation of the right to a fair trial, due process, effective assistance of counsel, and the right to be free from cruel and unusual punishment. Mr. Kohberger requests that the court exclude evidence and testimony that the state has not yet provided inadequate expert disclosures. An accompanying motion in limine has been filed regarding the specifics of this evidence. The details are not repeated herein, but incorporated by reference. Exclusion of that evidence, however, is insufficient to cure the whole of the prejudice to Mr. Kohberger. Okay? Like other trial courts around the country, this court must also, 1, order the prosecution to provide a detailed index of documents. Okay? Detailed index of documents it intends to rely on, as well as an index of Brady information. And 2, preclude the death penalty at the upcoming trial in order to meet the constitutional standards of due process and a fair trial. Mr. Kohberger acknowledges this motion requests preclusion of the death penalty as one of the remedies after this court's ordered deadline. However, good cause exists for this filing. So here what they're saying is this is after the deadline, right? Because as we discussed last night, all of their death penalty motions were filed back in September. But they were granted leave for file 2 additional, or the filing was like leave to file additional death penalty motions, plural. And we learned it was 2 because there's 2, but it was granted, right? So they had good cause. In other words, Judge Hippler already found good cause. The state has produced an enormous amount of disorganized data, continues to provide discovery past their deadline, refuses to provide requested supplemental discovery, and has failed to abide by expert disclosure rule and order. Now, why is this important, I think? Because like I was just saying, Judge Hippler already found that there was good cause. So what they're doing is this. They're saying, hey, Judge, you already found there's good cause. Why is there good cause? Oh, because of the state not turning shit over, right? In other words, it's like saying you already agreed, like, Judge, like you already agreed that this is the case. So we don't even need to argue this to you because you already made this finding. So look at this table of contents. Love it. A lot of this we know in terms of the history of the discovery. Now, there they go again with the Britannica. Here they're just giving different examples of how much information. Like, okay, yeah, we get it. How many photographs? More than 13,000 photographs. Okay. While the state has had access to many dozens or even hundreds, again, if you don't know the number, like dozens or even hundreds of detectives and investigators from multiple law enforcement agencies, including the FBI, in addition to the use of expensive AI and technological programs, they're using AI to facilitate production and review of this massive amount of discovery. The defense team consists of 3. Oh, I did that thing again where I edited this for them. That should have been a period there, but it's not. It's a comma. It should be a period. The defense team consists of 3 attorneys, a mitigation specialist, and 3 investigators. There's no way, even through the greatest of due diligence, that the defense can independently review all this discovery. Yeah, and they need another person to help them proofread. I will do it for free because it'll make my life easier when I read it. In providing discovery, the state has not provided it in a searchable format, has not provided detailed logs and indexes that would facilitate the defense's review of the evidence, and has not provided an index of Brady evidence or evidence that might be relevant to the defense. Yeah, and the reason I found that surprising is because I think in some courts that's not allowed. I was surprised. I didn't know it was allowed anywhere. I thought it was, okay, let me reiterate. I thought it wasn't allowed anywhere, but the fact that they're using it, now I'm like, okay, well, that means that it is allowed somewhere, but like I've only heard of it not being allowed until now. So that's news to me. I mean, speaking of which, there's like a lot of really interesting lawsuits regarding Chat GPT and lawyers using it and it fucking up everything. Additionally, the court set an expert disclosure deadline that passed more than 1 month ago. While the defense complied, the state provided vague disclosures. I remember all this. Well, of course, it wasn't that long ago. That failed to identify opinions that experts would provide or detail the facts and evidence they would rely on for those opinions. For example, the state's expert disclosure listed 3 alleged experts who would testify relating to the electronic devices, digital data, search warrant return data. The scope of that evidence is so broad that a defense expert estimated it would take more than 3 years to review. Yep, they said that already. The state did not identify any actual opinions it tends to elicit about these devices and failed to identify any portions of the data that would be presented or relied upon. Well after the disclosure deadline, the state turned over a report stating that the examinations of the devices are ongoing, which only heightens the prejudice to Mr. Kohberger and further depletes his time to conduct any independent review or evaluation of the state's case. This is only one of many disclosures in which the state failed to identify what opinion the expert would testify to and failed to point to specific evidence or discovery that would be relied upon. Moreover, even after this court told the state that its job was not done with its expert disclosures, I remember that, the state produced a circular argument. Yeah, it does that a lot, blaming the defense in its rebuttal disclosures about the electronics, digital data, and third-party warrants. No additional opinions, clarifications, or specifics were provided. And finally, Mr. Kohberger requested additional discovery related to IGG after he learned of its existence for the first time in his motion to suppress. The state acknowledged it had undisclosed information, but refused in part to provide it and promised in part to provide some information. No discovery has been disclosed. That's a problem. I mean, here's the thing. I'm going to highlight this. We know that with Lori Vallow, the death penalty was taken off the table for a discovery violation right before trial. I don't know. I don't remember the specific type of thing, but it was a discovery violation. And my recollection of the whole thing is how it worked there is her defense team filed a motion for sanctions, right, against the state. So it was a different pathway, I suppose. So I think it was a motion for sanctions, and one of the sanctions that they were proposing as a remedy was to take the death penalty off the table. But it was a discovery violation. I will say this much. Late disclosure. Was it expert witness disclosure? I remember thinking it was discovery, but the expert witness disclosure can fall into that category. You know, discovery is kind of a broad category. But here they're saying specifically as it pertains to the IGG. The only thing here, okay, let's look at what this hinges on, right? Because essentially this, right? If there's still outstanding discovery that the state has said they're going to turn over, the judges ordered it, states said they would, and it's not been turned over. I mean, yeah, like done deal. In my opinion, right? Judge Hibbler could still do it, whatever. But what does it hinge on? The state, so it's the IGG, right? The state acknowledged it had undisclosed information, but refused in part to provide it and promised in part to provide some information. Why do I not like this? Look at how much of this is like subjective and kind of vague. And why is that a problem? Because it gives the state and or the judge room to say that they did comply. So when you look at this and it says refused in part, provide it in part, promised in part to provide some information. You see what I mean there? Damn it. Now, we're only on page 6, so there could be other things, but this does not sound like, I just don't like it. It sounds like there's wiggle room or weasel room in there for the state and or the judge to be like, yeah, it wasn't, hopefully you guys see what I mean there. Like, it's just not explicitly clear. It's not like this thing we didn't get, I don't know. Yeah, it's just a bit vague for me. Yeah, thank you. I appreciate it. Yeah, there's a lot of oh, I see what you're saying, Tonka. I think actually it's actually a bigger error than that. It's so funny. There's these things. It actually, I think what it shouldn't. Okay, so Tonka's suggesting it should be no discovery has not been disclosed. I think what they meant to say was no discovery has been disclosed. So in other words, I think what they meant to do was not have the word not there. I think that's what they meant to do, because that's actually a stronger statement in my opinion. But I appreciate that you pointed it out, because I actually probably read it and either auto-corrected it in my brain, or maybe I even corrected it out loud. Okay, as discussed below, the state has gained a tactical advantage that, either or for sure, that cannot be remedied now, and therefore this court, is this what their whole thing is based on, though? Fuck. I'm going to just repeat it again before we get into the argument. If indeed there is discovery that the state has, they've acknowledged it, the judge ordered them to turn it over, and they still haven't turned it over, seems like a done deal, right? This is a big problem, right? Well, having said that, hold on. Let me recalculate. The thing is this. Okay, hold on. They're going to trial beginning of August. See, my brain was like auto-correcting and getting, because Karen Reed's coming right up. I was thinking this was like way closer to trial. See, like with Lori Vallow, for example, let me look it up. I think that was pretty close. I think that was really close to her trial. See, now I'm worried that there's an additional issue here, that because they still have some time, the remedy, like Judge Hippler could remedy this with just them getting it turned over. But anyway, that aside, the amount of time aside, again, see, now I'm like, oh yeah, August is still pretty far out. That aside, though, I worry that if it's all hinging on this and what they have and don't have and was promised and provided, it's like this languaging is so vague that, okay, let me do a quick search. Because the thing is that's actually going to be really important, because that's case law that, we've actually heard it cited already with this case, and I think others, because it's Idaho. So, so I'm just looking here. All right, here's an important thing. So 2 weeks before they started jury selection, Judge Boyce removed the death penalty. So let's see when the violation occurred. And this hopefully will also confirm that it was a motion for sanctions, which is what I think it was from my memory back when this happened. Wow. It has never happened before in Idaho. It was the first time a judge struck the death penalty. Judge Boyce said he couldn't find any case in the state for which removal of capital punishment had been considered or ruled on. There was no precedent for it. Wow. Good for him. I didn't even know that. Did y'all know that? I did not know that. Good for him. He set precedent. Well done, Judge Boyce. Okay, here's the motion. Hold on. Oh, it gave me an error. That sucks. Damn it. It was supposed to take me, a link was supposed to take me to the motion and it didn't work. Three disclosures were coming in. Judge Boyce said the items disclosed in March were inarguably and inexcusably late. So that's what I want to see. So how far before trial? That's going to make a difference here, guys. So this happened in March where they turned over more shit. He decided to remove it in late March. Let me just find that trial date. Idaho, I'm saying, dude. What year was that in? 2022? Maybe it was 2023. I'm pretty sure she went to trial in April. I feel like it was April. It had to be because closing arguments were May 11th. April 3rd. Okay, so this matters. Okay, so let's just confirm. April 3rd is when she went to trial. The disclosures that were turned over late were in March, so a month before trial. And that's literally, it's so funny because I figured it was in that, like, in my mind, it would have to be in that time frame. Like, that's what makes sense. And because of Karen Reed's trial being less than a month away, my brain like replaced it to where I was thinking, and then I remembered, wait, hold on, too many cases. This is not happening until August. That's still months away. How many months? May, June, like 5 months. So, yeah, I liked him as I liked Judge Boyce as well. Yeah, it's not unreasonable to ask for sanctions, but I think that it's too early. I mean, I guess you can't, it's not going to hurt to try, but like, yeah, again, like just to summarize, right? In Lori Vallow's case, that was the first time ever in Idaho that the death penalty had been struck. And just to reiterate, it's awesome because now there's a precedent. Shout out to Judge Boyce for that. But I think the only reason is because it was like less than a month before trial. So the timeline matters there. In other words, that was the only way to remedy that unfair prejudice to the defense. So if we're getting into July and the state is still turning some shit over to the defense, you better believe it's going to happen here. So, all right. Argument. Yeah, so we know they are required to turn shit over, right? Anything that might help the accused, either by negating the guilt, mitigating punishment, or impeaching the state's witnesses. That's Brady material. Prosecution has a constitutional duty to identify, preserve, and disclose exculpatory information. Again, we've read a lot of this verbatim in other documents. The state suppresses exculpatory evidence when it does not timely disclose this evidence. Oh, okay. That's not very clearly written, but I think I understand what they're saying. Why is this not Never mind. To comply with their constitutional obligations, the state must disclose exculpatory evidence in time for its effective use at trial. So the important thing here is this is the timing, right? Like, there you go. So in terms of Brady, exculpatory evidence. So now what's the standard for that, right? So materiality based on the impact of effective use with respect to when. So these are their different case law here, elaborating on that. When the state fails to produce exculpatory evidence in time for its use at trial, AKA, like, again, the Lori Vallow example, even though that wasn't the exact thing, but I'm just saying, like, in my mind, if it's like less than a month, that's, the state has, well, sorry. And I'm just thinking now, like Karen Reed, and it's like, the shit was getting turned over during trial. So there's that. The state has suppressed the evidence in violation of the defendant's due process rights. Additionally, when exculpatory materials have been disclosed too late for their effective use at trial, the untimely disclosure implicates a defendant's constitutional right to the effective assistance of counsel. And I think here what Judge Hippler is going to take issue with is the too late. Because I will say, in my opinion, it's not too late. If the trial was, I think there could be some wiggle room, maybe if it was like 2 months away, but it's not too late. They've got time, I think. The right to the timely disclosure of favorable evidence guarantees an accused sufficient time to investigate and evaluate the evidence in preparation for trial. In addition to allowing for full investigation, which could lead to more favorable or exonerating evidence, the timely disclosure of Brady material can alert defendants to viable pretrial challenges such as a suppression of evidence. Well, but if they turn something over that leads to another, like, in other words, if they get some new information, they can always file a motion and show good cause to file a subsequent motion to suppress past the deadline. Like, they have already done that with even this very motion that we are reading right now is an example of that, right? So that's not really a good reason to say, oh, well, the deadline's passed, so now I can't get it suppressed. Right. Prosecutors must turn over information at the earliest feasible opportunity as soon as practicable. Oh my God. Okay. Mitigating evidence is material when it may well have been consequential to a jury's deliberations on punishment. So this is only as it pertains to the sentencing phase. In death penalty cases, Brady includes information that may not exculpate, but that nonetheless mitigates punishment. Interesting. As such, even when the evidence is not probative at all regarding a defendant's guilt or innocence, or even when the evidence is more likely to support a finding of guilt during the first phase of a capital trial, the evidence may still be Brady material if it could lead to a lesser punishment. As the Supreme Court has emphasized, while evidence that is material to guilt will often be material for sentencing purposes as well, the converse is not always true. As such, when the state has elected to seek the death penalty, the Supreme Court has required a lesser showing of materiality to establish a Brady violation. Yep, that, as they should. A sentence will be reversed when the cumulative impact of the evidence may well have been material to the jury's sentencing decision. The obligation to disclose exculpatory evidence extends beyond what the prosecutors are personally aware of and beyond four walls of a prosecutor's office. It applies to, oh my God, this is literally verbatim out of what we just covered for Karen Reed as well. I'm not going to read anything else or something specific to this case because this is, we all know this, right? In other words, it's not just the prosecutor, so it's also the law. It's all this, right? We all are well aware, but literally just talked about this at length too for Karen Reed. I'm sure a lot of this is even the exact same case law. Right. The obligation of the state is to learn of and then disclose exculpatory evidence. Yep. So this includes the FBI. Now, this is important. Let's read this part. Therefore, a prosecutor's Brady obligation extends to exculpatory information obtained or possessed by any federal or investigative agency, including the FBI. Which is interesting, right? Because we know, how does the FBI get around this though? Because as we hear in every case, it's like impossible to get discovery via TUI requests. So like, how do they get around this then? That's my question. Because I guess if they say they don't have it, it's not exculpatory, but I don't know. It's just like, okay, taking them at their word. Lots of case law here. Wow, yeah, I don't blame, they're really backing that up. And that makes sense because of what I just said, right? In this case, we know there is discovery that the FBI is like, blah, 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 right? So I think that's smart to really provide a lot of case law in support of that. Idaho Rule 16A requires the timely disclosure of exculpatory evidence. Again, the timeliness of it all, as soon as practicable. Any material or information which tends to negate the guilt of the accused as to the offense charged or reduce the punishment therefore. Again, it extends past the four walls of the prosecutor's office. Can include witness statements. The Idaho rules of professional conduct. So now this is now they're relying on the ABA model rules, right? Again, this is so funny because we just fucking talked about all this stuff. That's not going to have any bearing on this filing, but yes, it's true that this is also a part of that. The ABA criminal discovery standards were further reflected prosecutors' well-settled discovery obligations, right? Okay, the prosecution has turned over mountains of. I mean, if you're gonna like, I would at least prefer you going back to the Encyclopedia Britannica thing. Better, that's at least more specific than mountains, and like, at least an encyclopedia contains paper with words on it versus mountains. Like, you don't have mountains anyway. The prosecution has turned over mountains of unorganized, electronically stored data that the defense counsel cannot possibly review prior to trial. I guess that's where, in terms of the timeliness that we were talking about, I guess that's why they keep bringing up the 3 years thing, because then that would be a way for them to get around the whole thing. Like, what is it, 5 months until trial? It's like, well, but it would take 3 years, right? I guess that's sort of how they're handling that. The problem, though, is like not having time to get through it all is different than having things turned over late. Okay. When exculpatory material is contained in voluminous amounts of electronically stored records, the state violates its Brady obligations by doing nothing more than turning it over, unorganized, on a drive. And like we were just talking about this, right? Like, so they've got a case law to support it. Again, this really varies. I mean, we see this happen all the time in cases where the state does this, and it doesn't ever result in it that I've seen. Okay, that I've seen doesn't result in any sanctions or motions or dismissal or anything. Brady violations. So they have one. So they're supporting. They've got one site to support this. Okay. Oh, interesting. Well, that's interesting. Because this case law says mountain, I think that's why they use the word mountain. Okay, I'm going to read this. In light of the above and return to the real problem here, it bears, this is from the case, this is from the holdings in this case. Let me just see what it is. This is from, This is not the greatest. Okay, so this is from a U.S. District Court. So it's federal and it's a lower, it's like a trial level court, right? If it's district court. So, and this is from, I guess it's California. This is not even strong, even as persuasive. Yeah, but it's what they have. So in that case, okay, the court noted, in light of the above and return to the real problem here, it bears repetition to emphasize that the ultimate issue is whether there is a disclosure in the letter and spirit of Brady Giglio, simply by turning over a mountain of everything acquired over half a decade and telling defense counsel nothing about where exculpatory impeaching information can be found. Again, the government cannot meet its Brady obligations by providing the defendant with access to 600,000 documents. Oh, and I wonder if the other reason they're using it is because they used the number of 600,000. Interesting. Now, what I will say, so this is California. What I will say is they do have, I know this because the EDV talks about it. Again, like I was saying before, how courts can have their own sort of practice, right? And it can vary by jurisdiction. In California, they do have, from what I've learned, right, like a more established, like they do have to organize shit and turn it over, right? Like I was saying. So, so this is not surprising that that's what they're citing, but that's not binding on this court here. Welcome back, Echoes of Clarity, who fell asleep, but now she's back with us. Okay. I mean, again, it's the right thing to do. They should be organizing it, but just because that's happening in California, and again, it should be happening everywhere, but just because it's happening in California is not going to be binding on a court in Idaho that they should be doing it there, or that they have to. Like, as far as it goes with case law. So, there's no authority for a conclusion to the contrary, and that it would be an evisceration of constitutional rights to shift the burden to the defense to review the records and identify Brady materials. I mean, so the thing is it's like, well, they turned it over, right? They turned over, well, okay. What's being discussed here is not that Brady wasn't turned over. It's that it's turned over, but it's buried, right? So essentially it's like they're trying to kind of say, and not just them, but anytime you've got this same issue coming up with, defense motions, it's like kind of like saying, well, it being buried, it's basically you may as well have not turned it over. Like that's not what they're saying, because like definitely they want it turned over, right? However, it's almost like not that much better because they have to be able to find it, right? Needle in a haystack. Okay, now they've got some other sites though. That's good. In the context of vast electronic records, even the circuit courts have adopted the most narrow approach to a prosecutor's Brady obligations, have held that the government must do more than simply produce the contents of these devices. Interesting. The Fifth Circuit held that this voluminous discovery did not violate Brady because the government provided copies of the electronic files to the defense. The electronic file was searchable. The government produced an index. Okay, so what they're doing here is they're providing a distinction in which there was a finding that the government did not violate Brady, and here's why it did not. And I guarantee you part of what it is because of this index, because what they don't have is an index, right? So they're saying they're going to be saying this is the difference, right? The electronic file was searchable. The government produced an index of hot documents indicating the documents were important to its case, right? And that's what they've already referenced that they don't have and they want in this case, right? And the government had created a number of other databases to assist the defense's review of the evidence. I bet that's probably California. Right. So they're saying because they did all that, right, they didn't violate it. I would agree. But that's not this case. Different case. There it is. The state has taken none of the steps beyond mere production. So what they're saying is here, production would be like step one. The state took this first step, but did not take the rest of the steps. I think that was a good case to cite there. The electronic file is not searchable. Defense counsel must locate and click into every separate document, of which there are many thousands, to find its contents. The state has not produced an index of documents that it will rely on in its case. To the contrary, the expert disclosure deadline has come and gone without the state identifying its expert's conclusions. So, and again, this came up in that hearing. This came up. And the Judge Hippler already remedied this. He already remedied this. And it was, I'm trying to remember what it was. It was unconventional. It was like whatever is already filed is what is filed. Like that's it, right? Like the deadlines are passed. If they want to have somebody testify something else or whatever, anything additional, like they're going to have to make a showing for good cause, right? For the court to extend that deadline to hear it, because And then as far as like the conclusions, he also talked about like, yeah, these are fact witnesses, not opinion witnesses. So again, I worry that with this, that the state, like when they talked about this, that the court already found that it did not agree with this. Like it was like this has been solved, like no longer an issue, right? So that's the thing. You don't want to be relying on something as like, here's part of why, this is part of the grounds here, but it's like something that the judge already feels like was problem solved. The state has not provided an index of Brady material, including exculpatory and impeachment information, nor an index of documents that are potentially relevant to the defense case. Indeed, the state has not provided anything to assist in the defense's review, despite the knowledge that it would be impossible, even through the exercise of due diligence, to identify exculpatory or impeachment evidence within the hundreds of millions of pages. And then again, with all this, with the hyperbole. Under the more exacting standards adopted by the other courts, or by other courts rather, it is even more plainly apparent that the state's approach to its Brady obligations runs afoul of Mr. Kohberger's due process rights. For example, the District of Columbia has rejected the Fifth Circuit's standards as too lenient, thereby directing the government to identify exculpatory information within its voluminous production. That's not good. That's not binding on this court. Okay. Example, the state has not timely produced indexed or identifiable portions of contents relating to the 67 electronic devices and warrant returns it intends to rely on. The defense must guess which form electronic reading software is utilized. For most devices, no specific report has been produced. For some devices, Axiom is used, and for some, Celebrate. Okay. Right, that's true. The software produces different results for the same device. Yeah. Yeah, they need to know which thing belongs to what device. That is for a fact. Yep. This is because modern electronic devices, including cell phones, have the capacity to store vast amounts of highly personal information. Yeah, for sure. I agree, Tonka. Given the capacity for a person's electronic, okay, we know all this, and honestly, this was in previous filings as well. We heard this also argued. Countless cases have been overturned due to prosecutors' failure to timely produce evidence that could have helped the defense identify a potential alternate perpetrator. Okay. Yeah, they said they referenced 67 devices. So phones, computers, tablets, things of that nature. I guess Alexa's, and here's all the case law there's citing there. Because many of these devices belong to the witnesses, the victims, and to people who knew the victims, including potential alternate perpetrators, defense counsel is plainly obligated to review them. Interesting. So in other words, because, like in every homicide, right? When you've got people that die, they're going to have search warrants for the devices of all the people that are their closest, their inner circle, as it were, right? Best friends, significant other, immediate family members, roommates, it's just, so in other words, that's why there's 67 devices, because you've got 4 victims, you've got the other roommates who are the witnesses. So that's 6 people, right? And then like all the people immediately in that, that's how you get to 67, I believe. And then no, I'm sure that's, we would not get to see that. Yeah, I think anytime that has been like referenced, it's been redacted. let me know if you got, no, I think the best we can do is try to guess based on what we know about the victims, such as like if it shows like who had Verizon or AT&T, but I'm not going to guess on who had what device when there's 67 of them. And, so we don't even know how many people. I was just thinking like starting with the victims and the roommates, that's 6, right? Already right there. So they haven't even gotten to the unknown DNA. This is just based on the case law that where is it? This is just based on right here. Countless cases have been overturned due to prosecutors' failure to timely produce evidence that could have helped the defense identify a potential alternate perpetrator. So this is just as it pertains to the devices. What they're saying is if they don't turn over these other devices in a timely manner, the defense could lose the opportunity to identify a potential alternate perpetrator, which they could identify from those from one or more of those devices. This is based on the case law. This is not even related to the IGG or DNA yet. They're making the argument, right, as to why it matters that the devices aren't turned over yet based on the supporting case law. Wait, how did you get to the... How'd you get to 21? You must not be starting. What are you starting with? You're not starting with 6. I mean, I would imagine that like the immediate family members, right? Best friends, yeah, in other words, so they're not unaccounted for. We just don't know because we don't know who the people are. But I can see how when you've got college kids and you've got that many people that live in the house and, their circle of friends, and then they've got their family members, I can see getting to 67. Like that does not surprise me. Okay, so you included Bryan in that number. Okay. Well, I don't think they've included, I guess maybe they included him. I feel like because they obviously have his device, they already have that, like of his. I assumed it was in addition to him. But yeah, okay. So if you include him, so then you have 7, right? Okay, that makes sense. That's how you got to 21. Yeah, I don't know. They didn't specify the 67. Does that include him? I just assumed it was in addition to, but I mean, I guess it does include him. I mean, it doesn't specify, but the word other is used for other digital data, but not other devices. So yeah, okay. And then you have to involve, his family as well, right? I guarantee all their devices were celebrated and axiomed and whatever. So again, when you think about all these people, and then they've got their friends, and then they've got their families. Okay, yeah. So because many of these devices belong to the witnesses, the victims, and to people who knew the victims. Right, there you go. People who knew the victims. So that's an even lesser, like maybe even just like somewhat friends, right? I mean, I don't know. In other words, it goes beyond just immediate family members, right? Including potential alternate perpetrators. Defense counsel is plainly obligated to review them. And again, with the 3 years part, of course, there is significant additional discovery, which is likely to contain exculpatory evidence related. Okay, this might be getting to, now they're talking about the tips. Okay. Of course, there's significant additional discovery which is likely to contain exculpatory evidence relating to alternative perpetrators. For example, the defense had to fight for the several thousand tips collected by law enforcement tip lines. Though these, oh my God, another typo, Tonka. Though these were, should say these, not there. Though these were in the state's possession the entire time, the state did not turn them over until more than a year after the case began. The defense has no way of knowing whether the state intends to rely on or introduce any evidence from those tip lines and has never received a log. I guarantee you they're not using them. Of Brady Giglio evidence. Because there is no log, an exact number is unknown, but the number of tips is more than 45,000. Tips continue to be reported. What's 49 divided by 3? Tonka, or anyone, if they know off the top of their head. Worse yet, the state apparently intends to rely on this evidence to establish guilt through 3 different experts, but has not identified what opinions these experts have drawn from the evidence, nor which parts of the voluminous data they are relying on. The state has created a situation where the defense is completely in the dark and cannot mount even a limited investigation into rebutting their experts' testimony, including by identifying impeachment evidence or evidence that contradicts their experts' opinions. Rather than cure this defect, when the court told the state that the job was not done with its expert disclosures, the state submitted. Okay, I was wondering if it was a prime number. That's really funny. What about 46 divided by 3? Okay, so right, when the job was not done with its expert disclosures, the state submitted expert rebuttal disclosures that blamed the defense for its inability to properly disclose expert opinions related to electronics, digital data, and search warrant returns. The state's failure to timely disclose this evidence in a meaningful way has prevented Mr. Kohberger from developing a full defense to the allegations in this case. They won't have time. Dang it. What's okay, hold on. Let me just pause. What's divisible by 3 that's close? Like 47? I'm trying to think. Hold on. 13 times 3 is 39. Wait. What number are we looking for? Sorry, wrong. We're looking for 4. Okay. Probably 15 would be the closest, right? 15 times 3, because that's 45. So that's because I'm trying to get, so it would be like 15 people or 16 people-ish, right? For the other devices, which really is not that many when you look at how the key people in terms of just the victims and the witnesses and even Bryan and then their immediate family members, that's really not that much when you think about it. Because like Bryan alone, what, dad, mom, was it 2 sisters, right? Like we know Kaylee's got her whole family. Ethan's got a whole family. So 15 times 3 is 45. So 48, wait, but 48 would be even closer, right? 16. Either way, 15 or 16, right, would be the other people, if I'm doing that math. Okay. So, right, they won't have time to do necessary follow-up. The failure of the state to identify important documents in the massive electronic data dump, including exculpatory documents, will hamper Mr. Kohberger's ability to meaningfully contest the state's theory. Moreover, the state's failure to identify exculpatory documents relating to the sentencing phase will prevent a capital jury from receiving a complete picture of the life of Mr. Kohberger supported by electronically generated records. Therefore, by dumping the contents of 67 electronic devices without identifying the pertinent information within them, the state has violated due process and all that. Okay. Reviewing the discovery is only the beginning of defense counsel's obligations. The defense must have time and opportunity to conduct independent investigation of the state's evidence. When the prosecution seeks the death penalty, defense counsel must independently investigate all evidence, whether testimonial, forensic, or otherwise, purporting to inculpate the client. Yeah, so Tonka's agreeing that that sounds like a good number for, like, yeah, I actually would have thought more, again, like, because, you know, these are all families of like 4 and 5 from what we know of, right? So, so yeah, I think that I appreciate that you helped us break that math down, Tonka. Before you inculpate the client. Okay, so they have to investigate that. In recognizing a large number of individuals sentenced to death who were later exonerated. Okay, so they're like, basically what they're saying is like, the ABA guidelines underscore the importance of their duty to do that. Okay, we don't disagree, of course, obviously, do it. This is a case where the facts are in great dispute. Mr. Kohberger asserts his innocence. There is no confession. There's no video or audio of the crime. There is no weapon. There's only trace evidence on a movable object, a knife sheath. Having full knowledge of the state's expert opinions and the documents they will rely on will provide leads for further investigation to uncover exculpatory evidence or to impeach prosecution witnesses. In addition to a complete investigation of every piece of the state's case, counsel is responsible for identifying and considering all legal claims potentially available, even if those claims have consistently lost in that jurisdiction, right? Counsel should object to anything. So they're just reiterating their job, like that they have to do as laid out by the ABA. Counsel should object to anything that appears unfair or unjust, even if it involves challenging well-accepted practices. This is necessary because counsel in a capital case has a duty to preserve any and all conceivable errors. Yeah. So the thing is, for anyone who didn't know, it's like, if you don't object, it doesn't make it onto the record, right? So like part of the reason why you'll object during a trial, even if you know what's going to get overruled, it's you're making the record for appeal. Because when they're going, the way that appellate attorneys work is literally they're going through and they're looking for where there's an objection. So if there's not an objection, they're not stopping. They're going to keep reading. So any and all conceivable errors for each stage of appellate and post-conviction review. Yep. As the non-preservation of an issue at the trial stage may result in a defendant's execution, even if reversible error occurred. In a case as complex as this one, the state's failure to direct the defense to evidence it will rely on in accordance with the court's schedule is highly prejudicial. It will undoubtedly impact the defense's ability to meet the evidence at trial, develop a comprehensive defense strategy, adequately respond to each aspect of the state's case, and complete all pretrial litigation about admissibility of the evidence. Even assuming the state discloses detailed expert disclosures and an index of hot documents tomorrow, counsel will need the remaining months before trial to conduct independent investigation into the evidence and witnesses, identify evidence that contradicts the state's theories, and incorporate all of the new information into the defense's case. It will not be possible to do this to the extent required in a death penalty. So here now what they're arguing is like, look, given the standard to which they have to follow from the ABA, they're like, it's not possible for them to do what's required of us in the amount of time. Similar to what we heard when they were going back and forth with the speedy trial. Thus is discussed below. So this is out. This is not going to go very far, right? Heightened liability standards. I mean, he's just going to be like, you get it done. Like, that's just what he's going to say. Oops. This is a capital case and heightened due process applies. I think we are well aware. I understand they have to say it again for the record, but we know. Mr. Kohberger has been prejudiced by the state's failure to fulfill its discovery obligations and judicial remedy is required. Because the state has failed to satisfy its disclosure obligations in a manner that would enable Mr. Kohberger to further investigate and incorporate exculpatory evidence into its defense for an August 2025 trial, Mr. Kohberger will be deprived of a fair trial and the right to effective assistance of counsel if the court does not remedy this situation. The court has wide discretion to remedy discovery violations as appropriate under the circumstances. Generally, when the state has failed to timely produce evidence, the court must choose between barring further prosecution or suppressing the state's most probative evidence. That's U.S. case law there. In past cases, courts have entirely dismissed indictments based on discovery violations to protect the defendant's constitutional rights, to sanction the government for misconduct, and to deter future Brady abuses. Lots of case law there. That's good. Mr. Kohberger is not requesting dismissal of the indictment for these violations, at least at this point. Footnote 5. Mr. Kohberger reserves the right to request dismissal if and when the circumstances warrant it. I appreciate this, and here's why. they're making it clear that they're not just being over the top, like, what's the right way to put it? You know, asking for way too much, right? There's another word I'm looking for. They're not being greedy. That's not the word. I don't know. There's another word, but they're not, in other words, they're not, this is important because what they're saying is they are going to reserve that right for when it's warranted, so that if and when they do request it, it's going to give it more weight, right? That they're not just frivolous. That's the word I was looking for, frivolous. That they're not just frivolously requesting it now, even though they, I mean, technically they could, but it's like, look, we're not going to waste your time. We're going to wait to request it if and when it's warranted. And that way, if and when that happens, it's like, hey, remember when we said we are only going to do it if it's warranted? So where was that? There it is. Okay. Because 5 months remain before trial. Oh, I was right about the 5 months. The defense believes there are remedies that this court can order short of dismissing the case that will likely remedy a significant amount of the prejudice. And here are their suggestions. So 1, preclude experts and testimony not properly and timely disclosed by the state. Mr. Kohberger requests the state be prohibited from introducing experts' testimony and underlying evidence that has not been properly detailed in an expert disclosure for which the deadline was January 9th, 2025. Again, unfortunately for the defense, like, he already addressed this to his satisfaction. So I don't think this is going to go very far with Judge Kibler. 2, require the state to provide a hot documents index of information it intends to rely on, as well as Brady Giglio evidence in accordance with the minimum standards for voluminous electronic discovery. And again, this was already discussed at length earlier. I think this should be required everywhere, but I don't know what they're going to say about it here because it doesn't seem to be required in Idaho. What I mean by that is there wasn't supporting case law out of Idaho for this. Most of it was federal, but that's different, right? They do things differently. So that doesn't surprise me. But that's just not, going to be all that helpful here, potentially. If Judge Hippler doesn't want to find in their favor in regards to this, in other words, he has a way to do that because of the case law, just like with the IGG, right? He can just be like, yeah, there's not supporting case law, sorry. Okay, now what they're saying here in this footnote is the state's current method of noting the date that it has produced a batch of discovery and the number associated with the disclosure pleading is not a detailed index, okay? As discussed above, evidence pointing to a possible alternate perpetrator or anything refuting the state's theory is bedrock Brady evidence, it should be included. Moreover, if this proceeds as a death penalty case, Brady material. So this is interesting. This is an interesting point. I actually like this argument. What they're saying is, look, you can either get rid of the death penalty, right? And then the amount of shit you have to turn over and, in the defense's view, also organize is less. But if you keep the death penalty, now the shit you have to do is more because the Brady standard is different, which is true. And then that was as it pertains to mitigation for the sentencing phase. And then 3, preclude the death penalty as a potential sentencing option. Courts have also precluded the prosecution from seeking the death penalty in would-be capital cases when the prosecution fails to satisfy their pretrial discovery obligations. The government may still seek a conviction and the serious penalty of life imprisonment, but no death penalty. So this is when it's done as a sanction versus granting a motion. So, like, in other words, there's a distinction, right? A motion to strike the death penalty is different than it being stricken. It's essentially stricken, right? But that's not the language they use is precluding it. That's when it's done as a sanction, like, again, in Lori Vallow's case, right? But even there, they used the word struck, even though, again, the way it happens in the pleadings is not a motion to strike, it's a sanction, right? Oh, there it is. Jesus, speak of the devil. Another Idaho trial court recently concluded that precluding the death penalty was the only way to cure the prejudice of disclosure violations by the state. Yep. The state had Bates stamped and previously provided more than 80,000 documents in discovery, but failed to turn over all this other stuff. And there it is, a month before trial. That's so funny. Well, yeah, the state's not going to, but this would be Judge Hippler's choice to preclude it. Like, the state's not going to, of course. But yeah, no, I wonder if you were saying that in reference to their argument about like more work to do or whatever. But yeah, no, it's an argument that they're making to Judge Hippler as a resolution or a remedy for this, for what they're saying. So yeah, so 30 hours of audio files. Yeah, there it is, month before trial. The court ruled from the bench. That's crazy. I didn't know I forgot he ruled from the bench on that. It's crazy. And signed an order. This is notably many, many multitudes less than the 68 terabytes of discovery. The time, though, they need to address the 1 month part. Like I said, that is the most important part in the distinction there. Though the prosecution filed the discovery only 1 day after the deadline set by the court, the defense argued that there was insufficient time for counsel. That's not the point. Oh boy. The point was the month. Oh my God. Court, they're not. You see what they're saying here is that the reason what they're saying is like the discovery violation here was because it was turned over 1 day late. That is not why. It's because it was a month before trial. Anyway, the court agreed and found that the dismissal of the death penalty was appropriate. Yeah. The court specifically found that the state had acted in good faith and attempted to disclose all discovery. Okay. The remedy was not in any way intended to be a sanction for bad faith or misconduct by prosecutors. However, the court said that death is different, right? Okay. So it wasn't really a sanction, more of a remedy. In other words, it seems like it wasn't the prosecutor's fault that shit got turned over late. I mean, I don't remember the specifics of that, but could have been something from the FBI, right? TUI, I don't know. Oh my God, look at that. That's just so not necessary. Anyway, Lori Vallow's case is distinguishable because she had not waived her speedy trial rights. However, in this case, it is the court that is repeatedly telling all counsel on Mr. Kohberger that the trial date is set in stone and everyone must be ready to proceed by July 30th. Hold on. Okay. The court has commented in other proceedings related to Mr. Kohberger's trial setting and motions about discovery and expert opinions. Okay. That Lori Vallow's case is distinguishable because she had not waived her speedy trial rights. Right. And that is an important factor. I'd forgotten about that. That is an important factor. This is shit. This is not a good argument for them. So now how they're following up with that is in this case, you've said this date is set in stone. Nope. Damn it. I forgot that she hadn't waived speedy. That does change things. Fuck. I already thought, well, again, the comparison isn't really going to get them very far because it's the 1 month versus 5 months. I'd forgotten also that she hadn't waived speedy. Yeah. And then to say that because the Judge Hippler says the date is set in stone, that's not and the thing is, I guess they have to make the argument. I feel like there could have been a better argument though, because this is just that's not going to get it. That's not going to do it. It's not the same. And they know it's not the same. Yeah, Tonka agrees. It's a good point, but it's not going to make a difference. Yep. Again, if shit is happening a month before trial, like again, even though she had not waived speedy and he did, I still think if they're turning shit over a month before trial, this would be different, right? Oh my God, what is happening with this? It would be different and it would still be possible, right? But the speedy trial thing is an important distinction, again, because it was setting precedent, and that's going to be a big part of the precedent going forward, is the fact that that was also specific to that case. So now the next thing is going to be like, if you've got a case where it's a month before trial and discovery or there's disclosures being turned over, but it's not, they did waive speedy, right? Then what? Be interesting to see. They're yeah. All right. Again, they're federal court. It's really not the standard. Is they need to find a better way to make it seem like there's similarities to Lori Vallow's case. That's, if they can, that would be what I would say. Or make a better argument. Like, I feel like there could be a better way to argue that, maybe. In a case like this one, where more than 68 terabytes of discovery has been produced, the failure to direct the defense to evidence and discovery it will use in support of expert conclusions are required by the disclosures. Several other judges have struck the death penalty as a sentencing option in response to disclosure violations as well. So, that's an NC case. Sweet. North Carolina Appellate Court. U.S. District Court. Again, it's not very compelling. Another U.S. District Court. So the most compelling, that's why it's first. The North Carolina Court of Appeals, that's their strongest case on that one. Mr. Kohberger has repeatedly brought forth, Meg's here. Hi, Meg. Facts that demonstrate serious prejudice to his due process rights. He has repeatedly raised the issue of the chaotic and disorganized production of discovery. He has repeatedly compelled discovery. I mean, this is the conclusion. So it's just in summary. Or well, maybe not quite yet. Seemed kind of like it. Indeed, other courts have precluded the death penalty on far less, and bad faith is not the standard of applicability for sanctions. Striking the death penalty is the only remedy that begins to adequately address the prejudice. Exactly. Yes, Tonka. They need to find a similar case where sanctions were applied because it absolutely. Yep, that's what they need to do. Now, the problem is this, is I guarantee you they tried. I guess if they didn't find it, probably it doesn't exist, right? Because, and that's why, like I said, if the thing that's going to be on point is going to be the Lori Vallow case. We'll go back in a second and see if there's a better way that they maybe could have argued that, even with everything being the same. Because if that's, in other words, if that's the case you got to work with, then maybe there's a better way you can argue it. Though counsel could proceed to a non-capital trial by making strategic decisions about what to follow up on in the limited time frame, counsel will not have time to complete the type of investigation. So they're conceding here that they will have enough time given the volume of discovery for the first part, which is making decisions, but that the follow-up investigation would be the thing where they wouldn't have time because of the mountains of discovery. Mountains. Precluding the death penalty is therefore necessary. And this is the summary paragraph, I think, here, right? This has not come in yet. Look at this. We have another one on the way. Motion to prevent death qualification of the jury. I have not seen that. I don't think that has posted yet. So there's going to be, oh boy. All right. We have that to look forward to. I'm excited for that. And here's why. Because I think it's really fascinating, the studies that have been done on like the psychology of jurors when they're death penalty qualified. I'm really excited to see what that says. Where did it scroll? Hold on. It scrolled all wonky like. Oh my God. No, we already read this. Right. That's where we were. Okay. So yeah, so that's the end. So now I'm going to go back to the part I was just referencing about Lori Vallow and see if there's a better way they could have argued that. Yeah. Fuck. Forgot about her not waiving speedy. God damn it. The court has commented in other proceedings related to Mr. Kohberger's trial setting and motions about discovery and expert opinions that Lori Vallow's case is distinguishable because she had not waived her speedy trial rights. Okay. One, I don't know if this is any better. The first thing I'm going to see if I can think of something better, but the first thing I was thinking, like a different argument they could have made is, however, so remember how for the longest time they were going with, he didn't actually waive speedy, but he was kind of forced to, right? Like, in other words, because he was being forced to choose between adequate, representation, right? Or, like constitutional rights. Like, they made that argument a lot, right? Like that you're kind of railroaded into waiving speedy or kind of accepting like ineffective assistance of counsel in a way. Now, like with Lori, one thing I will say is like her trial was delayed, I believe, because of like COVID. And then also she was away for a while as they were waiting to see if she would be found competent. However, when that happens, it stays the clock, as in the speedy trial clock stops ticking. But I believe that they can still continue to work on the case. I mean, I can't imagine that they just stop, right? So if they're still working, so in other words, I wonder if, well, maybe that's the answer right there. Maybe part of what they would want to say is like, yeah, she didn't waive speedy, but like because of the COVID and because of, like, I think it was like, I don't know why 9 months is popping into my head, but the amount of time where she was in that facility, essentially, I think she still had years, right? But they didn't violate the speedy trial clock, but she still like had years, right? So that could have been maybe an angle. But what I was going to say initially is like that they didn't really waive speedy, but they were forced into it. So trying to make it seem more like they tried to maintain speedy trial rights, if that makes sense. Right. That's right out. That was what I was saying. I think that actually, though, that was where I was starting. I think the thing about how much time did Lori actually have might have actually been better. I mean, that seems like maybe that would have been the way to go, right? Because I think she had years. I mean, she was arrested in let me double check. I think it was 2020. Hold on. Because we just looked at when her trial started and it was end of March 2023. She was arrested on February 20th, 2020. So I was right, 2020. So yeah, I mean, maybe that would have been the way to go, right? Like she still essentially had like years without waiving the speedy trial clock. So if you compare it that way, it's like the same amount of time, right? So I don't know, maybe that would have been a way to go. But yeah, that was the first thing I was thinking there. Right. The reasoning is a complex because, right, he was forced to choose, right. No, Lori had a public defender. It's the same dude. He's still doing cases. I hear him every now and again in different cases in Idaho. He is like the main, I think, death penalty public defender in Idaho. And he was busy, which is why they had to bring Ann Taylor in. But she's way better than him. So, yep. What's his name? It starts with a B or a D. Oh my God, what was his name? Yeah, he was a public defender. He was not good. And neither was co-counsel. Like Bryan Kohberger is not even a comparison, to be honest with you. Archibald, there it is. Jim Archibald. Yeah, because it's a really distinctive name. Jim Archibald. Yeah. And John Thomas. Yeah, they were not, no offense, but like, it was not good. I mean, obviously defendants don't have to put on a case in chief, but very rarely have I ever seen it where they just don't put on a case in chief. Like, obviously that's their right. I think that's the only case where I've seen that, where they literally don't put on any witnesses. And when it's like, okay, defense, it's your turn. And they're like, we rest. And it's like, okay. They did that. They did that. Yeah. I didn't like his attitude. He was rude and snippy and like, I don't know. In other words, I'm saying all this because like, if I was a juror, like I listened to that entire thing and I was like, if I was a juror, I would not like him. And that matters, right? Like that matters because if they don't like you, they're probably not going to be listening to you. Well, of course, everything is always their decision, right? With the advice of counsel. And because of attorney-client privilege, we'll never know how much of it was her idea and how much of it was their recommendation. I mean, could it, we just don't know. I mean, it seems clear, like the strategy obviously would have been to try to throw Chad under the bus. And we know she did not want to do that because she got pissed at him when he even just said something about the stupid books. She got really fucking mad about that. That was so fucking funny. Like, don't say his books are stupid. Yeah, and I don't blame them for not like Meg saying that they didn't like the prosecution in Casey. I don't blame them. The prosecution is horrendous and awful, rude, mean, inept, tried to hide things from the jury over and over again. The jury caught it, called them out on it. I mean, really, they could not have been worse. They could not have been worse. I mean, I will say the only thing good I can say is like, at least they don't say what if any a billion times a day. Like that, distinguishes them from Lolly, for example. So let's take a look here. Do they still do, let's see. I haven't looked at the case summary in a minute. Are we scrolling? Okay. Okay, let's see here. Well, you guys probably can't see that. I can barely see it. Let me zoom in. Zoom. Okay, that's all come out. Yeah, nothing else in terms of documents on the case summary that I see so far that haven't popped up. Now, of course, as things get unsealed or whatever, they could always pop up. But in terms of like going in chronological order anyway, like all of these are on the docket. We haven't seen the subpoena yet, though, I will say. Where was that? Here. I don't think that's posted yet because I've been looking for it. So that might be the next thing that comes up there. Interesting. So there's not really I'm sure there will be stuff, right? And it looks like, well, we already know because the defense was referencing it just a second ago in that other filing that they're going to be filing at least another death penalty motion. So who knows when that will post, but maybe soon. And then, anyway, so we're all caught up on Karen Reed. We need to get caught up on Shanna Gardner and Donna Adelson. But luckily, it's not like the court filings are like a bazillion a day, right? It's like there's just one or two. So it's not like a whole lot. So we can get caught up. No problem. But yeah, I think that'll be it for this one because we got through quite a lot here for these motions, guys. Awesome. I think, well, we'll see what happens today and what, if anything, what if anything comes out that's new. But what we might do tonight is we might either do Casey Anthony or we might do some more Murdoch for fun because I just love going back through the Murdoch. I already have these streams set up. They're just on private until I know like when I'm going to do them because it's like waiting on to see what happens with stuff, right? But I will just say that the next Murdoch one we're going to do, it's going to be Rogan Gibson with Snapchat video where that comes in. Will Loving, and then the defense double opens the door and there's a 403 analysis and then they jump into the trial within a trial. Oh my God. Just thinking about it makes me so fucking excited. It doesn't get any better. And that's all back to back. Like that's how it happens in trial, back to back to back to back to back. It's like, I remember that when it happened in real time and I was like, what is how can I even handle this? Like, it was so much craziness. It was so exciting and suspenseful. Oh my God, I love it. Yeah, I've had a lot of people request that, Meg. I've had a lot of people request that. So I'll definitely keep that on my in my list, or we'll definitely do that at some point. You're probably, I don't know. I've had a lot of people. So I'm glad you mentioned it though. The one that I'm thinking of doing after Casey Anthony in terms of like vintage trials, shout out to Flash for using that term because I like that term, is Michael Peterson, which is the Netflix documentary, The Staircase, from like a number of years ago. But that's a North Carolina case. And nobody's covered it. And I've never covered a North Carolina case. But that's a really interesting one that has a lot of controversy, and it has a lot of overlap because a lot of the same expert witnesses, there's overlaps with Murdoch, there's overlaps with Casey Anthony, there's overlaps with OJ. There's like a lot of overlap with the experts. Like that was a really high profile case. So a lot of those experts will know them. And also there was like, I think more than one alternative theory from the defense. Anyway, it's got a lot of interesting facets to it. And I remember it was, it's controversial as to whether he actually did it or not. And like, I saw the documentary years ago, so I don't really remember much about it. And I don't even know if I finished it, but like, there's he still has a lot of support apparently for like his innocence. So anyway, but that's one I was thinking of doing after Casey Anthony. So it might be that we do that and then maybe Jodi Arias, maybe. Which wouldn't be the worst thing, right? So that we don't have to, because Casey and Jodi back to back might be a bit like either two women, you know what I mean? I don't know. Oh, interesting. That was in Arizona, right? Yeah, you loved the documentary. Yeah. So, and of course, as we know, it's Netflix, right? So who fucking knows? I've not watched the trial. That's why I love watching these trials, because you never really know what all was, you never know anything. But it was a good documentary, and he was, he's a very interesting defendant because he loves to talk. All right. I don't know if he takes a stand or not, and I'm not going to look. I don't want to spoil it for myself or anyone else. But I could see him being someone who does. Just saying, because he talked a lot in that documentary, and he had high profile attorney. Also, I might recognize some of the scenery, right? Because it's Raleigh. So I don't know. It'll be interesting. And plus, another thing that I will love is getting to be familiar with North Carolina case law. More familiar with it. Yeah. But anyway, I think that'll be it for this one. So we will be back for more here soon, guys. And for anyone who missed it earlier, we did Karen Reed, latest documents, and we watched the Court TV Zoom thing that kept being referenced, and we also watched the latest juror interview with Vinnie Paulton as well. So yeah. You've never even heard of this, the unaliving twin sleepwalking case. That sounds insanity. Is that happening now? Or what is it called? I don't know this one. I'm like shocked. I'm like, there's a case I don't know. It doesn't happen all that often, I'm like, what? That's crazy. I mean, you had me unaliving twin sleepwalking. Sleepwalking, that's wild. That's got to be an interesting one, because I wonder, like, how do you work with that? Like, depending on what state it's in. Huh. That's you don't hear about, like, I wonder, are they going to try to get that in as an NGI? I don't know. Oh, it just finished. Interesting. Oh my God. Yeah, we'll have to watch that. What state was that out of? Wow. Oh, that's okay. That's okay. I can look it up. That's interesting. Wow. Did you watch it at all, or you just heard about it and you're like, yeah, I don't know. I mean, because it sounds like a good one. I mean, that sounds like a novel, issue for, like, to my knowledge. I mean, that's very specific. And that's one thing that'll be really interesting, is to see like what the defense does and what, you know, case law there is just to support like sleepwalking, you know? That's why I'm wondering, like, if they end up being able to go with like akin to like an NGI, like if there's not much case law specific to sleepwalking, you know, it'll be interesting. Okay, you just watched the mom testify. Okay, interesting. No, okay, no one covered it. Okay, well, yeah, we'll totally add that to the list at some point as things ebb and flow, for sure. I will make a note of that so I don't forget. I'm sure it'll be easy. I'll put sleepwalking. Twin sleepwalking. I'm sure then we'll find it. Twin sleepwalking. Thanks for the suggestion, Meg. That's a good idea. So, all right, well, guys, y'all are the best. Love y'all so much. Scroll crew for life, yo, as we say. And we'll just do a little 5 for the road. But yeah, other than that, I'll see you guys next time.